Recording in progress. Recording stopped. Recording in progress. Recording stopped. Recording in progress. Recording stopped.
Good morning. Good morning, Deputy Minister.
Morning, Chair, morning, members.
Recording in progress.
Good morning, honorable members.
Morning, Chair.
And let me welcome everybody who's on the platform, especially our stakeholders who have shown interest in the process of the IPID bill, and they're here to present to the committee, to empower the committee as the committee is busy processing the bill. You are all welcome, those who are on the platform. Welcome, Babalwa. Welcome, Nicolette. I see the Office of the Deputy Minister. Officials from the Office of the Deputy Minister are here. I see the Acting Secretary and your delegation are here. I see Sutu, welcome. Babamfundis, you are welcome from abroad. Thanks very much.
Thank you, sir. Good morning to you.
Good morning. Without any waste of time, I'm welcoming everybody who's on the platform. Can we check, Babalwa, if we are in quorum?
Good morning, Chair. Yes, we do have a quorum. You can start a meeting.
Thanks very much. The meeting is therefore officially open. Can we fly an agenda? Let's fly the agenda. Can't see the agenda. Okay. There's the agenda, colleagues, for today's meeting. We'll get opening remarks. We'll get a presentation from the content advisor. We'll then get a presentation from APCOF. We'll get a presentation from AfriForum, followed by FXI, followed by FW de Klerk Foundation, followed by IPUSA, followed by Meridi Haas. We'll then have a lunch break, then come back, continue with the presentations from Difuna Ukwazi, followed by Pop Crew, followed by CLPO, followed by South African Human Rights Commission, then close the meeting. If we are happy with the program for today, can I get a motion for adoption?
Honorable Chair, my hand is up.
Yes, Honorable Gomba.
Honorable Chair, I hereby propose the adoption of the program for today.
Thank you. Honorable Blanche.
Chairperson, I just want to inquire about the responses that we were supposed to be getting today. I don't see anything on the program for that, and that is just my question, Chairperson. Thank you.
Thank you. I guess you are, Honorable Blanche, you are referring to the responses from SAPS.
Yes, sorry, Chairperson. Yes, that's exactly what I'm referring to.
I think we might deal, because today's program is so pregnant, we might deal with them maybe on Friday. But I've seen that there are certain responses that were sent to the committee from SAPS. Will that be fine with you?
Chairperson, yes, it's fine. My concern is just, this is now the second meeting that we had, that this stuff was supposed to be available, and my concern is it now, or my question is it available, yes or no?
Babalwa, what have we received? Babalwa Nicolette.
Good morning, Chair. Good morning, honorable members. Chairperson, unfortunately, the SAPS requested an extension until tomorrow, which I will submit the written responses, and this was due to the the nature and scope of the questions that was posed. Chair and the committee agreed to allow the SAPS to only submit tomorrow.
Okay. So it means by Friday we'll be having those responses.
Yes, Chair. We will receive it tomorrow, and then it can be discussed on Friday when the department will present their challenges and successes over the sixth administration.
Okay. Honorable Terplanch, definitely the department will respond the latest by tomorrow, and then they will be tabled on Friday in our Friday's meeting.
Thank you, Chairperson. Noted by me.
Thanks very much. The motion has been put forward to adopt the program, which will guide us in today's meeting. Can I get a second? The motion was by Honorable Gomba. Can I get a second? Can I see? I don't see hands. You can shout if you are unable to raise your hand. Honorable Marekwa. Honorable Molekwa.
Morning, Chair.
Yes, Honorable Marekwa.
You're calling me?
Yes. Are you seconding the proposal by Honorable Gomba?
Oh, okay, Chair. Thanks. Good morning. I do second.
Thank you. That will be the program that will guide us for today's meeting. Like it was indicated to our guests, that the program, if need be, the program might be flexible to an extent to allow certain processes to take place. But for now, we'll be guided by the program as it has been suggested, moved and seconded. Like I said, today, the Portfolio Committee on Police is hosting the first day of public hearings on the Independent Police Investigative Directorate Amendment Bill. The public hearings are in line with Chapter 59 of South Africa's Constitution, which compels the National Assembly to facilitate public involvement in the legislative process. Furthermore, the legislative sector adopted a public participation model that places public consultation at the center of how it does its business. We are scheduled to receive 9 oral briefings during today's meeting, and we welcome all participants present. Under our constitutional mandate to facilitate public hearings on legislation, presenters will be allowed sufficient time to address the committee, but we do request that presentations be to the point. The public hearings follow a decision to adopt the motion of desirability by the committee on the 6th of September 2023, in line with National Assembly Rule 286.6. On that day, the majority view was that there is an urgent need to strengthen, through legislation, the institutional and operational independence of the IPID and give effect to the Constitutional Court judgment in the case of McBride and Vice Minister of Police and others. Much have been said about Clause 4 of the amendment bill, and as a committee, we are fully aware of the constitutional defects of the clause. The matter has been canvassed during various portfolio committee meetings. It is a regrettable situation, but the ministry has stated their case and has acknowledged the deficiencies. As a committee, we have noted the reasons put forth by the ministry and decided to process the amendment bill and not to close the door on this important debate. In upholding our mandate, the deficiencies in Clause 4 will be rectified. From public submissions, it is clear that the issue raised significant concern. On behalf of the committee, I request participants not to only focus on the deficiencies of the bill, but to offer meaningful solutions to strengthen the operational and structural independence of the IPID, especially in terms of the appointment process of the Executive Director. We appreciate the exceptionally high quality of public submissions received on the amendment bill. We are grateful for the interest shown and welcome the willingness of stakeholders to work with Parliament to create impactful legislation. In closing, we must keep in mind that the amendment bill covers a wide array of proposed changes to the Principal Act. I ask that we do not lose this focus by concentrating exclusively on Clause 4 of the bill. The challenges are clear and they will be addressed. We welcome submissions on all clauses of the bill and appreciate the views expressed therein. These views will invariably assist the committee during deliberations of the amendment bill in its comprehensive review of the Principal Act. May we have fruitful engagements during today's hearing and also when we continue with public hearings scheduled for next week, Wednesday. Having said that, I will then now call upon our content advisor, Nicolette, to make a presentation. Nicolette.
Good morning, Honourable Chair and Honourable Members. Members, I'm not going to be very long. I'm just quickly going to take members through the public submissions process and what we have received.
Nicolette, have we lost you?
No, Chair, sorry, I'm just
Okay.
a bit of a challenge here. There we go, Chair. Apologies for the delay. Honourable Chair, the call for public submissions was opened on the 12th of September, and the advertisements were published in all official languages in national and regional newspapers, as in line with Parliament's public participation framework. The deadline for submissions was set for the 2nd of October and was extended to the 6th of October to allow for late submissions, which we've received quite a number. Additional to the publication of the call for public comments, the committee also launched a social media campaign to create public awareness on the bill. The chairperson of the committee issued several media statements to also create public awareness, and the committee has identified 17 stakeholders in the policing environment, which we've directly invited to make submissions on the bill. Honourable members, in terms of our mandate, the committee have received 22 substantive written submissions on the bill, and these are from established organizations, universities, and stakeholders. The committee has also received 37 non-substantive submissions through the organization Dear South Africa. These were only like one-worded submissions in terms of whether they support the bill or not. And as been done in previous cases, these submissions are essentially seen as one global submission and not counted as individual submissions. As you can remember, in the Pokutara Bill, the committee received over 25,000 non-substantive submissions from or through Dear South Africa. Honourable members, from the 22 substantive submissions, 18 identified or stated that they will address the committee orally, and this will happen today and next week. Honourable members, to accommodate the largest number of participants, we are having both virtual and physical public hearings. As I stated, today is the first day, and next week, Wednesday, we'll have the physical meeting in Parliament. Chair, I can state that the hearings will be held in room S12A in the NCOP building, just for future reference. Chair, one of the critical issues that was raised by submissions was the issue of the national preventive mechanism under the OPCAT. And this is the only area raised in submissions that I will highlight. This issue was also mentioned by Honourable Ter Blanche in Friday's meeting on the IPID annual report. Honourable members, as part of the optional protocol to the Convention Against Torture and Other Cruel, Inhumane, or Degrading Treatment or Punishment, so-called OPCAT. South Africa has ratified this protocol in 2019, and as part of that, Parliament established the National Preventive Mechanism. This mechanism is coordinated by the South African Human Rights Commission, and the Human Rights Commission will present later today, and they will give an extensive overview of their role as part of the NPM. And IPID forms part of this mechanism under OPCAT. The presenter coming straight after me, Mr. Sean Tate from the African Policing Civilian Oversight Forum, will also raise this issue. The Association for the Prevention of Torture, and also, like I said, the South African Human Rights Commission, as well as the African Criminal Justice Reform Project, raised the significant need to legislate for the National Preventive Mechanism. Honourable members, in terms of this mechanism, we have requested and received a report from IPID on the impact of the NPM on their capacity and resources, and this will be shared with members soonest. But naturally, Chair and honourable members, significant resources are needed to fully effect this mandate. Honourable members, the committee has also requested a legal opinion from our parliamentary legal services on the inclusion of this mandate in the IPID Act. Honourable members, because South Africa has ratified the convention, it must be domesticated in national legislation. Specifically, we asked the legal services to provide an opinion on whether the provisions for the mandate under OPCAT or the NPM should first be made in the Prevention of Combating and Torture of Persons Act of 2013, which is our guiding legislation on the prevention of torture. Chairperson and honourable members, our Torture Act predates the ratification of the OPCAT, and so we must first receive clarity whether it will be preemptive to amend the IPID Act currently, but we await the opinion, which will be submitted next week. Honourable members, I'm just quickly going to take members through the schedule of the processing of the bill. Today we are having the virtual public hearing. Next week, on the 25th of October, we'll have the physical public hearing. On the 1st of November, we'll have departmental responses to the public submissions. On the 3rd of November, the committee will start deliberations. On the 8th of November, the committee will consider and adopt our public participation report and continue deliberations. On the 10th of November, the committee will go clause by clause consideration of the bill. On the 15th of November, the committee will consider the A-list of the bill. On the 22nd of November, the committee will adopt the committee report on the bill as well as the bill in its entirety. Honourable members, thereafter, the bill was scheduled for the second reading debate in the NA before being transferred to the NCOP for concurrence. Chairperson, honourable members, that concludes my presentation. Thank you.
Thank you, Nicolette. I don't know, DM, do you have any comment?
No, I thank you, Chair. Good morning to you. Good morning to members, and morning to the invited participant for this meeting. It's an honor and privilege for us to be part of this important process, Chair. I think what Nicolette has outlined is very straightforward in terms of what needs to happen, and we should agree and support those processes, Chair. We will, through our team, the Civilian Secretariat, it's here because they are the custodian of this, or they are the people who are leading the processes of drafting this piece of legislation. So they will participate in all the hearings. They will take notes of what the public is saying and other organizations that have made input. And I think somewhere is the third or the second, Nicolette is saying that we are going to respond as a department to the committee on those comments, and we'll do accordingly. And I'm quite confident that we are not going to have challenges. I think the issue of international conventions, I think those ones we will have to be guided by, you have rightly invited the legal people to come and to come and advise on how that should be handled. I think we should carefully craft them in such a manner that we don't create a problem for ourselves like we have done with other conventions, where we just endorse all of them without reservations, and it makes life difficult for the country. Hence, there is a process now to review some of them. So I will urge that let's do it in such a manner that we don't open ourselves up only to come and want to make amendment at a later stage, because we just took everything as presented and put it into our own situation, and it makes law governance very, very difficult. But generally, I'm happy with what you have outlined, and our team, like I said, will be working with the committee throughout. We understand why we are going through this route, and we'll try to be supportive of the processes. And if there is any matter that the committee will want us to clarify, even before the time that we must come and respond, we will be willing and ready to do that, Chair. We will support the process through and through. I just wanted to indicate that there was a miscommunication. We thought, excuse me, we thought the meeting will be done by 1, but I see we're going beyond that. I'm supposed to be traveling. So I will just, when we break for lunch, I will quietly disconnect, Chairperson, but the team will remain, and my office will also remain with you on the platform. Thanks very much, Chairperson.
Thanks very much, DM. Thanks very much. At that time, yes, you can quietly disconnect. Is there a comment from any member of the portfolio committee regarding what Nicolette has presented? Honorable Groenewald.
Good morning, Chair, and all the other members on the platform. Now, I want to use this opportunity to just say that I will apologize. I will not be available from 11 o'clock. But I think what Nicolette presented was a good summary of the process. Thank you.
Thanks very much, Honorable Groenewald. Thanks very much. Okay. Honorable members, let's proceed with our program and invite African Policing Civilian Oversight Forum to present. It is now 30 minutes past 8. We're giving you 20 minutes to present, and the committee will engage with your presentation for 10 minutes. If you are able to finish before that time, the better for all of us. Because we don't know each other, even if you have connectivity problems, just show your face when you introduce yourself, then you can switch off your video to allow you to continue. Can we call a representative of the African Policy and Civilian Oversight Forum?
Thank you, Honourable Chairperson, Honourable Members, Honourable Deputy Minister, sorry. Thank you very much for the opportunity to be able to present before the committee. I have a short PowerPoint presentation, and I will share my screen to enable that. Thank you. Honourable Chairperson and members, I have three preliminary comments, and then I will move through some substantive comments on the bill and be mindful of the time available to me. So in terms of the preliminary comments, I just want to draw the committee's attention to the fact that the Independent Investigative Directorate Amendment Act 2019, that's Act 27 of 2019, which was assented to by the President, must still be operationalized by gazetting the date into which it comes into operation. And we would urge the committee to address this as soon as possible. Then, as the content advisor alluded to, South Africa has ratified the optional protocol on the Convention to Torture, Cruel, Inhumane, or Degrading Treatment or Punishment, the OPCAT. This has been a decade in the making. OPCAT requires a country essentially to do two things. One is to criminalize torture, and the second is to establish a preventive monitoring system. Preventive monitoring is to be able to assess conditions within all places of deprivation of liberty, and advise around risks and the way in which those risks can be addressed specifically through to the mandate holders. It works in conjunction with the Subcommittee on the Prevention of Torture based in Geneva, and is part of the obligations of South Africa in terms of the Convention Against Torture. Now, South Africa decided in the ratification of OPCAT, and this was after a long debate on this national preventive mechanism, the form and shape that it should take. And it was decided at that point, and this has gone through all the processes, the JCPS cluster, etc., around not establishing a new oversight mechanism, but rather to harness the capacities of our existing oversight mechanisms. The Office of the Inspecting Judge, JIX, the Military Ombuds, the Health Ombuds, the South African Human Rights Commission, and in terms of police custody, the capacities of IPID. This does mean that there are amendments needed within the IPID Act to provide for preventive monitoring. At the moment, IPID has the mandate to investigate torture. That's very clearly was set out within the Act, but the monitoring capacity is not, and we need to bring that into play. The point was made that should we perhaps wait for the preventive mechanism to be formalized within the Prevention of Torture Act. I think currently what is happening is that the preventive mechanism is established. It is recognized. We have had a meeting and we've had a visit by the SVT. They have given inputs into around how the preventive mechanism can be strengthened. And in essence, it is operational, and IPID is fulfilling its duties within that national preventive mechanism. It does mean that there are, and as was alluded to, resource constraints and also mandate issues. And as we're looking at the amendment of the IPID Act, this is a very opportune moment to actually bring that in and consolidate IPID's role within that. And I will come back to this later when I speak to some of the specific issues in the bill. And then the third issue is around disciplinary recommendations. And we make a comment within the bill around the importance of trying to strengthen IPID's role when it comes to these recommendations that are made to SAPS. The points made here are simply to say that there's a concern within the SAPS disciplinary process. We've seen declines there in terms of the number of inquiries and processes held. We've had research that sees SAPS essentially neglecting its responsibilities when it comes to discipline and shifting this to IPID and allowing the IPID process to go forward. And we know as well that in terms of the recommendations that have been forwarded to SAPS for discipline inquiries, we're not seeing kind of meaningful response to that. And in the 22-23 report of the almost 800 recommendations made, we're still waiting feedback in 378 of those cases. So we bring this into our considerations around as well. Honourable Chairperson, I'll now move to the substantive issues. And the first is the objective. And we are encouraged by the stated aim of the bill in terms of ensuring the Directorate is impartial and able to exercise its powers and functions without fear and favour. However, we submit that the word impartial could rather be replaced by the word independent to be able to give full effect to the judgment. We then move on to the definitions. And here, Honourable Chairperson, we provide proposed definitions for the national preventive mechanism and preventive monitoring. And these be included in the definitions with a view towards then including them in the mandate of IPID. So the NPM is an independent mechanism for the prevention of torture, either designated or established in accordance with Article 18 of OPCAT. And the preventive monitoring is making announced and unannounced visits to places where there may be persons deprived of liberty to strengthen their protection, and includes assessing all relevant documentation, persons, and the ability to conduct in confidential interviews. We also note that the bill provides for the terms operational independence and institutional independence. These haven't been defined, and we propose the following definitions for those two terms. In the interest of time, I'm not going to read them out. Then referring back to the issue of strengthening the disciplinary recommendation mandate of IPID, we believe that this can be strengthened by defining what it means to initiate. And we have proposed that instead of being left open, and which could be simply, I've received it and I'm thinking about it, that it includes the following, that the SAPS or the municipal police services would have to appoint a chairperson and an employer representative. They would have to serve the charge sheet upon the member. They would need to hold the first sitting within 30 days of the receipt of the recommendations from IPID, and they should extend an invitation to IPID to bring evidence before the inquiry. And this would then certainly clarify what it means to initiate and strengthen that process. Then under independence and impartiality, we welcome this inclusion, but we feel that the section can be strengthened by the substitution of subsection 1 with the following paragraph: the Directorate functions institutionally and operationally independent from the South African Police Services and the Municipal Police Service, and any structure associated with the the National or Provincial Secretariat of Police Services or Ombudsman where it exists. And we propose also the following inclusion: that the Directorate has full legal capacity, is independent, and is subject only to the Constitution and the law, including this Act. Honourable Chairperson, you made mention of the process of the appointment of the Executive Director, and we have proposed the following process that draws Parliament into the appointment process in a very clear and direct way. So that when there is a vacancy, a committee is established by the National Assembly to initiate the appointment. The committee submits its report and recommendations to the National Assembly. There is a time period of 14 days within this process. The National Assembly has 30 days within which to consider the report and the recommendations of the committee. That this is then adopted on the basis of a 60% vote of members of the National Assembly. And thereafter, we propose that it is the President who shall confirm and then take steps to formalize the appointment of the Executive Director and not the Minister. I think this would then further strengthen and consolidate the independence of IPID in this process. I think this is continuing in terms of the appointment process, but we also think that we need to include a provision that the Executive Director not perform any remunerative work outside of his or her official duties. Then we move on to the function of the National Office. And here, Honourable Chairperson, we submit that the identification and review of legislative requirements needs to be done directly by IPID and not through the Secretariat, and then reported directly to the Ministry. And again, this is in the interests of independence, that IPID is best placed to understand its legislative requirements and needs, and is able to then prepare and manage that process and does not have to work through the Secretariat to be able to do that. On appointment criteria for investigators, again, one of the benchmarks for successful police oversight is its resourcing, both in terms of financial and human resource and technical capacity. We are concerned about the deletion of the criteria requirements for investigators. We believe that they must have at least a grade 12 certificate or relevant diploma or degree. The investigative core is the backbone of IPID, and by removing these criteria, we are in effect juniorizing investigators, and whereas we should be strengthening and building that capacity and providing for stronger investigators. And I think the entry requirement here should at least be a grade 12 certificate. In terms of remuneration, we don't agree with the changes to section 23, which allows for the salary to be determined by the Minister in consultation with the Minister of Finance. We are concerned that this will also undermine the financial independence of IPID. We know that section 23 had originally been included to ensure that IPID investigators' salaries and benefits were on a par with SAPS detectives, to ensure that IPID investigators are not lost to SAPS for better salary packages. Rather, we propose that this clause or provision be read that the salary be set within the allocated budget, be set by IPID within the allocated budget, voted for by Parliament. We don't see the reason for the ministry determining salaries here. We now look at the functional mandate areas of IPID. The first is complaints relating to the discharge of an official firearm by any police officer. We propose that this be retained. In our submission, we note that there are few checks and balances when it comes to reckless use of firearms by officers, and that this is one of them. We also propose that this actually be expanded to include other weapons that fire projectiles and beyond, including those less lethal weapons such as rubber bullets, tear gas, tasers, and pyrotechnic devices. We know that these weapons are often used and misused in acts of torture. And again, I think the complaint mandate will strengthen our oversight and accountability over these. When it comes to torture, we submit that the investigation of allegations of torture not be limited only to those that present grievous bodily harm. The definition for torture includes psychological harm, and as we know, the Prevention of Torture Act came after the IPID Act, and I think we need to just take the definition out of the Prevention of Torture Act, and that this be any complaint of torture as defined by that act committed by a member of the South African Police Service or a member of the Municipal Police Services. Assault, we submit here that all complaints of assault should be investigated by IPID, and this be retained. Assault is an abuse of power, and it's very difficult to make a distinction between assault and assault GBH. It's often subjective. It's often only based on visible injury, and it follows investigation. And that by limiting it to GBH, you are going to undermine the ability of IPID to be able to address these abuses of power. We agree that attempted murder be included as a category, but that this not only be limited to the use of a firearm and should include any allegation of attempted murder. Here, Honourable Chairperson, we provide for an inclusion of preventive monitoring into the mandate area of IPID, and this will allow IPID to play its role assigned to it through its participation on the National Preventive Mechanism established under OPCAT. Honourable Chairperson, we also submit that IPID can make meaningful impact on improving police performance by identifying and tackling and responding to systemic challenges through its analysis of data and its understanding of crime types and where these crimes are being generated, how they're potentially linked to problem officers, stations, or units. IPID can proactively make a significant difference when it comes to tackling and reducing these violations. So we submit that the mandate include a research component that can provide greater emphasis on proactive engagements with SAPs about problem areas highlighted. Then we turn to disciplinary recommendations. And again, in addition to the definition of initiate, we do not agree with the proposal that SAP's disciplinary processes only be initiated after the IPID investigation has been finalized. And we think that this will lead to significant delays in the disciplinary process. And as I spoke about earlier, we see that there was already serious problems in the management of discipline process within the SAPs. It is the responsibility of SAPs and the NPS to manage discipline and to do this expeditiously as possible. An IPID investigation, even in parallel, will determine whether the allegations warrant further referral to the National Prosecuting Authority. And if it's found that no action has been taken by SAPs, then IPID would have the power to compel the initiation of that disciplinary process. We also submit that given what seems to be kind of significant number of cases being withdrawn or being not found guilty, we also propose that the provisions in Section 30 be expanded to be able to empower IPID to compel SAPS to review cases where the sanction might be found to be too lenient or thought to be too lenient. And then finally, I think, is the issue around offences and penalties. We know that officers who fail to provide or comply with Section 29 in terms of reporting cases within the IPID mandate to IPID are guilty of an offence. This is a fine or a period of imprisonment not exceeding 2 years. We submit that that range of the fine also be established. And again, we believe that this will provide further incentive in terms of compliance with Section 29. Honourable Chairperson, that concludes my presentation. Thank you.
Thanks very much, Honourable. Your name is Sin Tate.
That's right. Sean Tate. Thank you, sir.
Okay. Sin is the name, Tate is the surname.
That's right, sir.
Thank you very much. Thanks very much for your presentation. Can I check with honourable members if they have questions for clarity or inputs with regard to the presentation? If it's Honourable Terblanche. Honourable Terblanche, followed by Honourable Marekwa.
Chairperson, thank you for the opportunity. No, I don't have any specific questions. I think it is quite clear, and I just want to commend the presenter on, the presentation made, and, obviously touching the very issues that this committee has been battling with, over the period, in terms of, our concerns regarding discipline. And then, obviously another important factor is, the capacitation of oversight bodies and oversight mechanisms. I really think that is the essence of taking, IPID forward. And just thank you very much again. Thank you.
Thank you, Honourable Terblanche. Honourable Marekwa.
Thank you, Chairperson, and good morning once more. Chair, mine is just to say that we noted the presentation as has been tabled this morning, and I think we will still have more time to go on clause to clause and all other issues, but for me, it's just to note the presentation. Thank you, Chair, for now.
Maybe before you respond, Mr. Tate, you said with the appointment, the signing of the appointment letter, I guess, if I was to simplify it, of the executive director must be signed by the president. And the IPID is not a Chapter 9 institution. And maybe you can school me. IPID is not investigating minister or deputy minister. What's the rationale behind that? Thank you.
Thank you, Honourable Chairperson. Thank you to the members for their comments. Referring back to the appointment process, it is in terms of the perception in the eyes of the public of the independence of the Directorate. We know from the judgment as well that there must be functional independence in terms of that appointment process and the role of Parliament in that. We submit that that could be further strengthened if the appointment is made directly by the president, as is done with, for example, the NPA or other Chapter 9s. I don't think that there is any reason why it cannot be made by the president or assented to by the president. But obviously, I refer to the wisdom of the committee and to the state law advisors in terms of whether this is a valid process or provision. Thank you, sir.
Thank you. I don't see any hands. I think, like members said, they appreciate your presentation. We're still going to engage with it, with your presentation. Thanks very much for your time. And I think you'll get feedback. You are allowed to be part of the process moving forward, just to monitor how are we moving with the issue of processing IPID. Thanks very much. And thanks for your time. Thanks very much.
Thank you, sir.
Can we move to the next presentation by AfriForum? The same principle will be applied. Your presentation is allocated a maximum of 20 minutes, so that we give a time about 10 minutes to members to engage with your presentation. AfriForum.
Good morning, Chair. Thank you very much for the opportunity. My name is Jacques Brederick. I represent AfriForum and our 315,000 members. So I'd like to start off by just saying that AfriForum acknowledges and strongly emphasizes the critical role that the Independent Police Investigative Directorate plays in ensuring oversight, accountability, and transparency. Within the South African Police Service, as an organization deeply committed to upholding the principles of justice, democracy, and the rule of law, we believe that an independent and robust mechanism for investigating and addressing allegations of misconduct and abuses of power by law enforcement officers is not just desirable, but absolutely essential. I'm going to move on to specific concerns that we have regarding the bill, and I'm also going to keep it brief because we went into a lot of detail in our written submissions, and as Chair requested, time is unfortunately limited, so I'm going to keep it as brief as possible. In the context of appointment process for the Executive Director, it is crucial to assess the proposed changes in the new IPID bill. The current proposal, which suggests that the Minister of Police appoints the head of IPID with the approval of the Cabinet, raises concerns. By vesting such a crucial decision solely within the Executive, there is potential for the selection process to become embroiled in internal power dynamics and political maneuvering. Unfortunately, this is something that we've seen in other spheres of government quite often in South Africa. I could mention the state capture debacle as one example. The absence of checks and balances in this proposal heightens this risk. The integrity and independence of IPID's mandate demand a selection process insulated from all undue influence, which is why we think it would be a better idea if the selection process still went through the entire parliamentary process, as other Chapter 9 institutions as heads get selected. Furthermore, while it's not to cast aspersions on the intent of any specific past Minister of Police, the historical precedents have shown that personal biases, affiliations, and agendas do influence unlawful decisions. Such a scenario could compromise the very foundation of the IPID. To ensure the long-term credibility and functionality of the IPID, the appointment process must be shielded from any potential vulnerabilities and prioritize the broader interests of South African society over transient political considerations. It is concerning to note that the current bill seemingly operates in contrast to the overreaching goal of any amendment to enhance the principles of trust, transparency, and effectiveness. The bill proposes explicitly diluting the provisions for the appointment of the IPID Executive Director by marginalizing Parliament's role and consolidating the power of decision-making largely in the hands of the Minister of Police and the Cabinet. Such centralization not only threatens to erode public trust, but as mentioned before, also heightens the IPID's susceptibility to political interference and potential manipulation. The proposal seems to neglect the importance of diverse voices from both the legislative branch and local decision-making bodies, underscoring the value of localized decision-making in matters of national significance. The shift is particularly perplexing given the backdrop of the 2019 amendment of the IPID Act. The amendment commendably fortified the watchdog's independence by instituting safeguards against the arbitrary removal of the IPID head. In this context, the present bill seems a step backwards, potentially undermining the strides made towards reinforcing the IPID's autonomy and credibility. I'm going to leave it at that. Thank you very much, Chair.
Oh, thanks. It was very short. Mr. Jakes. Jakes is your name, eh?
It's Jacques, sir.
Jacques.
Surname is Bredrijk.
Surname is Jacques.
First name Jacques.
Okay.
Surname Bredrijk.
Oh, thank you very much. Thank you very much. There is a presentation, honorable members, from AfriForum, represented by Jacques. Do you want to interact with the short presentation? Honorable Gomba, followed by Honorable Terplanche.
Thank you very much, Honorable Chair. We note the presentation and the submission. Thank you very much.
Thank you, Honorable Terplanche.
Chairperson, yeah, thank you. I also want to thank Mr. Broderick for his presentation. It is really appreciated.
Thank you very much, Mr. Broderick. The committee accepts your presentation and will engage with the presentation as we process the bill, but you are still allowed to follow the process 100% to see whether what you have presented is getting its way into the bill. Thanks very much.
Thank you, Chair.
Thank you. Let's receive the next presentation from freedom of expression. Freedom of expression.
Good morning, Honorable Chair. Chair, I don't think the organization has joined yet. We are trying to contact them, but in the meanwhile, I think the FW de Klerk Foundation is on the platform, and if Ishmael can maybe indicate its availability.
Yes, Honorable Chair, I am available.
All right, representing FW de Klerk Foundation.
Thank you, Honorable Chair. I have a presentation to share with the committee, so I would like to share my screen.
Yes, you are a co-host, I can see.
Honorable Chair, I'm not exactly certain how to share my screen. If you could just assist.
Nicolette, can you assist? Is your presentation with the office?
Yes, Honorable Chair. If the office could share it.
Thank you, Ishmael. I'll share it from my side.
All right. I see the Executive Director of IPID is here. You are welcome, Mentla Tseng.
Thank you very much, Honorable Chairperson. Good morning.
Good morning to you too.
Thank you, Honorable Chair. I may begin my presentation?
Yes.
All right, I represent the FW de Klerk Foundation. This is our oral submission on the Independent Police Investigative Directorate Amendment Bill, Bill 21, 2023. Moving over to the next slide. My name is Ismail Jusub. I am a legal officer of constitutional programs at the FW de Klerk Foundation. If we can move over to slide 3, we see that the objectives of the FW de Klerk Foundation are outlined. The FW de Klerk Foundation is deeply committed to upholding the Constitution and advocating for the values, rights, and principles it enshrines. In particular, we are concerned about how the IPID Amendment Bill might impact fundamental rights, the foundational principles of our legal system, and the independence of IPID, which is crucial for maintaining public trust and ensuring accountability within law enforcement. So given the time constraints, Honorable Chair, we will endeavor to address these vital concerns within the time allocated. My next slide, slide 4, speaks on the introduction. If we can go back to the introduction slide. In our written submission, Honorable Chair, on the IPID Amendment Bill, we as the FW de Klerk Foundation emphasized the need for a balanced and transparent appointment process, echoing concerns raised in the Constitutional Court's directives. The Constitution's principle of separation of powers, enshrined in Section 1C, underscores the distinct roles of the legislative, executive, and judicial branches to prevent undue consolidation of authority. This principle is fundamental to the democratic governance of South Africa, aiming to maintain a system of checks and balances, ensuring that no one branch oversteps in its authority or interferes unduly with the functions of another. And in this, Honorable Chair and Committee, the FW de Klerk Foundation has concerns with Clause 4 of the bill. Clause 4 of the bill, we believe, by concentrating substantial appointment powers in the hands of the Minister of Police and Cabinet, seemingly contradicts this principle by potentially subjecting IPID to undue influence. Now, we believe that this concentration of power within the executive branch stands in stark contrast to established international norms, which we'll touch on, and best practices that we'll touch on, that advocate for a transparent and merit-based selection process for key positions in oversight bodies. In my subsequent slides, I will also delve into international law, elaborate on our specific concerns. I'll address the potential implications of IPID's independence and the necessity for a transparent and balanced appointment process. If we can move over to the next slide titled Legal Background, I'd like to touch on that. Committee, let's now explore the legal underpinnings of the IPID Amendment Bill by referencing valuable insights. The IPID Amendment Bill, we believe, is critically rooted in a legal context, notably the Constitutional Court's judgment, as you've mentioned, in McBride versus Minister of Police. This landmark case highlighted constitutional deficiencies in the original IPID Act, particularly sections 6.3a and 6.5, which granted the Minister of Police unilateral powers concerning the executive director of IPID. The McBride case serves as a turning point, exposing critical flaws in the original IPID Act and emphasizing the need for substantial revisions. The Constitutional Court's judgment highlighted that the original act gave excessive powers to the Minister of Police, including the authority to suspend or discipline the executive director of IPID without the necessary parliamentary checks and balances. And this essentially is what we as the FW de Klerk Foundation are against. The McBride case underscored the need for legislative action. It emphasized the importance of a transparent and impartial oversight body, which would then not relegate or subjugate IPID to a lapdog and would keep its significance as a police watchdog. What we believe now has happened is that the IPID Amendment Act has, through its recent additions or through its recent amendments, given the Minister of Police excessive powers, thus relegating it to the status of being a watchdog instead of a lapdog. If we can move over to our next slide, concerns. The concerns of the FW de Klerk Foundation relating to the IPID Amendment Bill are as follows. Firstly, as I've mentioned, the concentration of appointment powers. Secondly, we believe that it is in stark contradiction to the principle of separation of powers. Thirdly, we believe that the IPID Amendment Bill compromises autonomy and public trust, alluding to what my former colleague has said. Fourthly, the FW de Klerk Foundation notes the potential conflicts that the IPID Amendment Bill has with international norms And fifth, we'd like to touch on the non-alignment with the McBride case directives. So let's move over to the concentration of powers, of appointment powers. That's the next slide. Regarding the concentration of appointment powers, we believe that Clause 4 of the IPID Amendment that the Clause 4 of the IPID Amendment Bill grants extraordinary powers to the Minister of Police, allowing unilateral selection of the Executive Director of IPID. Now, we believe that this disproportionate authority to a single executive figure centralizes control and potentially thus undermines the checks and balances envisioned by the Constitution. The previous version of the IPID bill aimed to create a more transparent and independent selection process for the Executive Director of IPID. However, now we find that the current version, particularly in Clause 4, significantly deviates from this intent, maintaining substantial appointment powers with the Minister of Police. So by allowing a single entity, in this case allowing the Minister of Police, substantial control over such a critical appointment, the potential for undue influence and political interference becomes a great concern indeed. It is also very alarming, we find as the FW de Klerk Foundation, that the Minister of Police, on behalf of Cabinet, has knowingly introduced a bill to Parliament which the Chief State Law Advisor has declared as unconstitutional. The proposed IPID Amendment Bill also gives the Minister of Police the power to determine the remuneration of IPID investigators in consultation with the Minister of Finance. As the FW de Klerk Foundation, we believe that this is increasingly draconian, and we do not stand for this provision. We believe very much that the original intention of the IPID bill was to establish a more transparent and independent selection process for the Executive Director of IPID. But we have great concerns with Clause 4, which we believe deviates significantly from this initial intent by now granting the substantial appointment power to the Minister of Police. If we can move over to our next slide titled Contradiction with Separation of Powers Principle. The clause within the IPID Amendment Bill that concentrates appointment powers in the executive branch presents a fundamental contradiction to a core constitutional principle, namely the separation of powers principle enshrined in Section 1C of the Constitution. The Constitution envisages the separation of powers to distribute authority among the executive, legislative, and judicial branches, as mentioned, thus preventing an undue influence of power. In the case of the IPID Amendment Bill, the concentration of appointment powers within the executive branch, particularly within the Minister of Police, disrupts, we believe, this delicate balance intended by the Constitution. It provides an extraordinary level of authority to one branch, the executive branch, allowing a single entity to wield significant control over a critical aspect of what should be, we believe, an independent oversight body. This we believe centralizes power within the executive and disrupts the intended checks and balances offered by the Constitution. If we could move over to our next slide, titled Compromised Autonomy and Public Trust. On this slide, you see exactly what we as the FW de Klerk Foundation are against. The essence of any oversight body, such as the Independent Police Investigative Directorate, lies in the trust it commands from the public. Public trust forms the bedrock upon which the effectiveness and the credibility of oversight bodies rest. It is essential that the public has confidence in IPID's impartiality and autonomy, for this trust ensures the credibility in holding law enforcement agencies accountable. However, we now see that the, as mentioned, concentration of appointment powers, specifically by Clause 4, contradicts these democratic principles and potentially threatens IPID's autonomy. Such a concentration of power risks subjecting IPID to political influence, eroding the public's trust in its unbiased functioning. Moreover, this deviation from the Constitutional Court's directives in the McBride case is also for us deeply concerning. The court in the McBride case, the Constitutional Court, emphasized the need for IPID's independence and a transparent selection process for its executive director. The present version of the IPID Amendment Bill strays from these directives, undermining IPID's independence and the principles highlighted by the court. This diversion thus does what? it diverts public trust and confidence in our oversight processes. To ensure the long-term credibility and the functioning of IPID, the appointment process, we as the FW de Klerk Foundation believe, must be shielded from any potential vulnerabilities and prioritize the broader interests of the South African society over transient political considerations. We must stand firm in upholding the values and principles upon which our democracy stands as enshrined in the Constitution. If we can move over to the next slide. Our next slide is titled Conflicts with International Norms. There we go. The United Nations Universal Declaration of Human Rights, to which every country in the world should behold, emphasizes the importance of transparency and public participation in governance. The concentration, we believe, of appointment powers in Clause 4 could thus hinder a transparent and inclusive selection process, deviating from these international norms. International best practices such as the basic principles on the independence of the judiciary, which is called the BJIP principles, stress the need for checks and balances in key appointments. The concentration of appointment powers in the executive, as proposed in the bill, may contradict these principles by bypassing a more balanced and inclusive approach. The United Nations Universal Declaration of Human Rights underscores public participation as fundamental in public governance. Clause 4 of the IPID Amendment Bill, by concentrating power in the hands of the executive, critically hinders all international standards of the United Nations and hinders that critical belief. In today's interconnected world, we cannot view legislation as an isolated fact. Our laws and policies indeed must align with international norms and standards. Another thing that we examine with the IPID Amendment Bill is its critical lack of alignment with the United Nations principles on the effective prevention and investigation of extra-legal, arbitrary, and summary executions, which emphasize transparent appointments or transparent oversight appointments. And this also, we believe, conflicts with the bill's approach. The Constitution provides that all law must be read with international law. And we believe that the only way that the IPID Amendment Bill can be now further changed or should further be changed is if it now further aligns with these international norms that we are stressing. If we can move over to the next slide, titled Non-Alignment with McBride Case Directives. So delving deeper into the divergence between the IPID Amendment Bill and the directives set out by the Constitutional Court in the McBride case. The McBride case brought to light critical constitutional shortcomings in the original act, as already mentioned. The court emphasized the need to limit the minister's powers concerning the appointment of the executive director of IPID. We believe that the court's intention, and it's been stated that the court's intention, was to promote impartiality and independence and to prevent undue political influence in the appointment process. The court thus underscored the necessity for a transparent and inclusive process to ensure public trust and confidence in IPID's vital oversight functions. However, now, despite the clear directives from the McBride case and the need to align legislation with these directives, the IPID Amendment Bill, and specifically Clause 4 within the IPID Amendment Bill, deviates from this intended alignment. Instead of addressing the court's concerns and working towards fulfilling its directives, the bill intensifies, it does the opposite, the antithesis. It intensifies ministerial powers in the appointment process. This deviation compromises the core principles highlighted by the court and undermines the very spirit of the court's judgment, which also erodes public trust. So in reviewing now what we have at our disposal, the IPID Amendment Bill, we find a stark disparity between the legislative intent on the one hand of the Constitutional Court, the court's directives, and what has actually culminated in the IPID Amendment Bill. The Constitutional Court's call for a balanced and impartial appointment process has not been adequately reflected in the current version of the bill. The misalignment is thus a cause for concern, as it raises questions about the legislative fidelity to judicial directives. It shows a disregard for the court's directives. If we may move over to the next slide. The FW de Klerk Foundation thus makes the following suggestions. Firstly, a balanced appointment process. Proposing a balanced appointment process is something that we propose to ensure that the selection of the executive director of IPID involves multiple stakeholders, reducing the potential for undue influence, which would thus promote transparency. Secondly, we suggest legislative oversight and approval. We advocate for legislative oversight and approval in the appointment of key IPID personnel to ensure democratic checks and balances on the executive's power, which thus would align with the Constitution, the Constitution's directive or the Constitution's mandate for checks and balances. Thirdly, we suggest transparent and objective criteria. We suggest clear, transparent, and objective criteria for appointments to enhance fairness and credibility in the selection process, promoting the selection of the most qualified candidates based on merit. This is something that currently is lacking within the IPID Amendment Bill. Fourthly, we suggest adherence to international norms. It's also been lacking in the IPID Amendment Bill, something that I've already touched on. The FW de Klerk Foundation emphasizes alignment with international norms, such as those that I've mentioned, ensuring that IPID's appointment processes resonate with internationally recognized standards, promoting credibility and fostering international cooperation. And lastly, we suggest alignment with the McBride case directives. We reiterate the need for the alignment with the directives from the McBride case to ensure that the IPID Amendment Bill effectively addresses the constitutional deficiencies highlighted by the Constitutional Court, staying true to the original intent, rectifying these issues, and not reverting back to the root of the problem that was seen in 2016. I'd also like to mention in this regard that by not following or by disregarding the McBride case directives, what the IPID Amendment Bill does is denigrate public trust to the extent that it promotes a level of nefariousness within the Department of Police. It suggests a level of political nefariousness on the part of the Minister of Police. And so thus we therefore suggest this alignment with the McBride case directives. If we may move over to our last slide, to our second last slide on last resorts. The FW de Klerk Foundation therefore proposes sensible safeguards as a last resort to the IPID Amendment Bill. We propose the establishment of a transparent and consultative process for the appointment of the executive director of IPID, involving multiple stakeholders, including civil society, for checks and balances. We then suggest the assurance of legislative oversights by requiring approval from the National Assembly for the appointment and reinforcing democratic accountability. As it currently stands, Parliament does not play a part in the appointment process. And so we believe that the IPID Amendment Bill should therefore be rectified so that the Minister of Police needs to get that go-ahead, that green light from Parliament in the appointment process, which we believe would be in complete alignment with the Constitution, which would be contrary to what is currently stated in the IPID Amendment Bill. And thirdly, a sensible safeguard, we believe, would be to base the appointment process on transparent and objective criteria, as I mentioned, aligning with international norms. So moving over to the closing slide. In conclusion, honorable members, these recommendations aim to strike a balance, addressing the genuine concerns raised by various stakeholders, legal experts, and political parties. By embracing the recommendations that I've just mentioned, we can work towards the appointment, or an appointment process rather, that is truly transparent, impartial, and in line with constitutional and international norms, and is also in the spirit of the McBride case. The IPID Amendment Bill warrants careful scrutiny, therefore, to concerns about the concentration of appointment powers, contraventions of constitutional principles, potential impacts on autonomy and public trust. Upholding these concerns is crucial for safeguarding democratic oversight and public trust. Thank you very much for the opportunity to present to you on the IPID Amendment Bill. I now open to any questions.
Thank you very much, Ismail. Any input, honorable members? Honorable Terplanch.
Thank you, Chairperson. I want to thank Ismail for, I think, what I would term an excellent presentation. I think this is very informative, and I find it to be very helpful, in ensuring that, what we are going to end up with will be something that will be aligned with the Constitution and obviously also the McBride case. Thank you very much again for the presentation.
Honorable Gomba.
Thank you very much, Honorable Chair. Honorable Chair, I would like to note the presentation since we are going to receive more inputs from other organizations, and we will sit as a committee and work on all the presentations. For now, I think it will be good for us to just note and not comment and make recommendations yet. It's not yet the time, Honorable Chair. Thank you.
Thank you very much, Mr. Ismail.
Thank you,
your
Chair.
presentation is well received, and it will be seriously considered as the committee process the bill. Thanks very much. Can I call upon the next presenter, Ipusa? Ipusa.
Chair,
Yes.
Ipusa, they are struggling to join, but I'm still trying to assist them. Can we maybe move to the next presenter?
Mary DeHaas. Mary DeHaas. Can I be advised? Where's Mary DeHaas? Okay.
Chairperson, maybe we can move over to Poklu if they are available.
Okay. Pop Crew, are you available? Pop Crew?
Good morning, Chair. How are you?
Fine. Is that Pop Crew?
Yes, this is Pop Crew.
Are you ready?
Yes, we can go through our presentation, Chair.
Thank you. Please continue.
Okay. Let me extend our greetings to members of the committee and colleagues that are online from different stakeholders. Chair, before we proceed with our presentation or submission, I would like to extend our apology from our NOBs who are currently held up in other organizational commitments, because we're preparing for our 10th National Congress, which is sitting next month, early next month. So they are held up with other organizational commitments. And myself as a parliamentary officer, I'll be taking through the committee. I'll be taking the committee through our submission, and I'm with my colleague on the line, Comrade Mbele, and also Comrade Pasha. Without wasting any time, Chair, with regard to the submission on the IPID bill, Hope would first like to welcome this opportunity to participate in this process, which was triggered by the Constitutional Court ruling on the invalidity and unconstitutionality of some of the provisions, including other amendments to the Principal Act. We are not going to only look at the unconstitutionality picked up by the Constitutional Court, but to extend or to take our submission beyond the court ruling and look at other issues of the Act which are posing a serious concern to our members in the IPID. Our submission, Chair, on Section 4, we welcome the insertion of the subsection 3, which we believe that it will enhance the independence and impartiality of the IPID. The IPID, we believe, must be an institution that must perform its mandate without any undue influence from the minister or any other political head. It must be insulated from the political influence when it conducts its operations. And then on Section 6, Chair, is a section that deals with the appointment of the executive director of the IPID and also removal of the director, the ED. And this is a contentious section because it's the one that forced the erstwhile executive director of the IPID to lodge an application with the court. So our view on this section, Chair, is that we actually first welcome the insertion in the heading with inserted the enumeration and the condition of service. But with regard to Section 6.1 of the Principal Act, we, as the minister was the only one with the powers to nominate a suitable person to appoint the IPID executive director, we now note amendment made in Section 6, subsection 1, which now provides that the minister with the concurrence of cabinet shall appoint a person as an executive director to head the directorate, the IPID. We view that as, because we said that the cabinet is the highest range of the executive. So we feel that there must be a consultation with cabinet to appoint the ED of the IPID. We believe that with this amendment, powers will be taken away from the minister, and then the process of appointing the ED of the IPID will be a transparent and independent process. And we therefore believe that it is not going to be a compromised process, and the institution itself will never be compromised because the ED will have not been appointed by the minister or any political figure. We further, Chair, welcome the deletion or repeal of subsection 6 in the Principal Act, and we welcome the insertion of Section 6A, which deal precisely with the removal. We submit that powers and process to remove the executive director of the IPID must be taken away from the minister. Hope Crew urges that there must be an oversight body like Parliamentary Ad Hoc Committee to oversee that process of the executive director's removal. We are basically here saying, Chair, that the very same way that the ED is being appointed must be removed, the very same way. The Committee of Parliament must be the one that removes the executive director of the IPID. On Section 7, Chair, we concur with the insertion made to Section 7.6, subsection 6A of the Principal Act, The new insertion incorporates and recognizes other relevant heads of police in all three spheres of government. And also, when the complaint is against the commissioner of the police, then it will mean that of the national commissioner, it will then mean that there must be a report to the president through the minister of police. On Section 8, Chair, Hope Crew welcomes amendments made to Section 8, including the heading of section which now reads appointment of members of national office. In subsection 5 of Section 8, we submit that the reasonable turnaround time be attached to the issuance of the security clearance certificate. We must avoid a situation where a person is employed for more than a year without a security clearance. That is our view, Chair. And we go to Section 22, which is not which was not part of the Constitutional Court ruling, but pertaining to the investigators or our members in the IPID. Section 22, Pope submit that Section 22 on appointment of investigators be amended as follows. Pope submit that Section 2B, Roman figure 2, must be amended to read as follows. 2, a person appointed as an investigator must have relevant qualifications and experience. This is in contrast to, is contrary to this section in Principal Act, which reads that any other relevant experience. Pope says that the person must have relevant qualification and experience, not just any other relevant experience. Pope further admit that subsection 4 must also be amended to read the pre-employment security vetting investigation contemplated in subsection 3 must be conducted by the relevant and competent agencies. Here, Chair, we're being specific which agencies are those. We are saying that the South African National Defence Force, Crime Intelligence, and State Security Agency, not any other agencies. These are the 3 agencies that we have identified to be the one that must conduct security vetting. On section 23, Pope knows the insertion that gives Minister of Police in consultation with Minister of Finance powers to determine conditions of service, including salary and allowance of IPID investigators. Pope holds a firm view on this section, Chair, that benefits of IPID investigators be aligned with that of investigators of SAPS. The streamlining of benefit will ensure the adequate allocation of budgets to SAPS. We are now moving to section 28, Chair, which is also a contentious section of the Principal Act, which I don't think has been reflected on the bill. Section 28, Chair, in section 28, Chair, you are saying that there must be a fundamental amendment to this section, especially subsection 1B of the Principal Act. Section 28(1) provides that the Directorate must investigate death as a result of the action of a member of the South African Police Service or a member of Municipal Police Service, whether such member was on or off duty. Chair, we want to critically raise this as Pope that we submit that this section 28, subsection 1B, puts police officers at a vulnerable and helpless position whenever are confronted by heavily armed criminals whilst executing their constitutional mandate of preventing and combating crime in the country. Firstly, whenever police officers are confronted by these criminals, they effectively become handicapped because they know that if they exchange gunshots and subsequently kill these criminals, they will be charged, investigated, and prosecuted. It must thus be noted that the rise in police killings occurred during this incident. I believe members of the committee and stakeholders that are in this meeting will know that yesterday in Intuzuma, a police officer was killed when he was confronted by the criminals. I'm just talking about an incident of yesterday. So he was killed on duty. He was on duty, this police officer. He was killed by criminals. So that's why I was saying that this Section 28 must be fundamentally amended. And what is happening? Chair, I think the people who are joining, I don't know what is happening. Hello?
Oh, thank you very much.
Continue.
Can I continue?
Wait. Yeah, continue, Pop Crew.
Okay. One of the things that we need to raise with regard to this section is that, or this kind of thing is that when these police officers are charged, Chair, they are expected to individually cover the legal costs. An example, we find that these cases drag for long and it's taking much on the budget. And it must be remembered that these police officers were doing this while they were when they were executing the official.
That is the executive management.
Yeah, I'm being disturbed by Vosim Kize. I'm not sure what is happening. I don't know what is happening.
Mr. Vosim Kize. Can you hear me? Mr. Vosim Kize? Mr. Vosim Kize? Okay, Nicolette Babalwa. Mr. Vosim Kize? Nicolette Babalwa, please call him to mute his mic. It's not his time as yet, so that we are attentively listening to the presentation by Pop Crew. Please call him. Pop Crew, continue.
Yeah, as I was saying, Chair, that these police officers are expected to individually cover legal costs for alleged offense committed while discharging their constitutional duty. This put a serious financial distress on our members because they end up footing huge legal bills defending themselves in court. We submit that IPID must not in any way impede police officers from executing their functions. Hope further submit that all legal costs associated with these cases must be covered by the state. The duty of the state attorneys is to handle criminal and civil litigation cases instituted against the officials and committed by means of acts or omissions while executing the official duties. Therefore, all such officials must be assisted by state attorneys to cover the legal cost of cases emanating from performing their official duties. We have the view that that the principle of vicarious liability must be invoked when we're dealing with these cases. In conclusion, Chair, PROPRI is of the strong view that statutory oversight bodies and crime prevention and corruption fight institutions must be protected from an undue political influence or any other form of influence to compromise their independent operations. We further believe and want to emphasize that the independence of these institutions, both operationally and on accountability, must not be compromised by legislative defects. POPRUS believes that amendments and submissions made to this bill will assist in protecting the IPID against undue influence, currently restoring its independence. We further argue that IPID must not be turned into a state organ that will impede police officers to do their job. Most importantly, we are of the view that working relations between members of the SABS and the IPID must be improved to ensure effective policing functions through legislative amendments such as Section 49 of the Criminal Procedure Act. Our men and women in blue who work tirelessly to protect the inhabitants of this country also need to be protected from heartless criminals who often undermine the rule of law. A popular member will always be a priority to ourselves. Chair, this is the end of our submission. As I've indicated that I'm with my colleague Mbele, maybe we may want to add something, or maybe we'll take questions at be posed at the later stage. We thank you, Chair.
Thank you very much. Sir Paul, representing Pop Crew. Honorable members, there is a presentation from Pop Crew. Can we interact with it? Honorable Terplanch.
Chairperson, thank you. I want to thank Chairpo for his presentation. It's really very, very encouraging to get inputs from our organizations active in the police itself. I think that is also very helpful. And thanks for the presentation once again.
Thank you very much, Honorable Terplanch. Thanks very much, Pop Crew. The committee will interact with your input as they process the IPID bill. Thanks very much. Thanks very much. Ndifuna ukwazi. Are they here? Ndifuna ukwazi.
Morning. They are not on the platform yet, as I was scheduled quite a bit later. But the presenter from FXI is available. Famelo.
Okay. Freedom of Expression Institute. Are you available? FXI?
Yes, we are available.
Please continue with your presentation.
Yes, thanks very much for this opportunity to give our input on the IP bill. As we indicated, basically the FXI deals with the right to freedom of expression, and it was founded in 1994. And we basically focus on defending and promoting the right to freedom of expression and to oppose censorship, fight for the right of equal access to information and knowledge, and to promote access to media and a free press. And I'll just go right into the presentation. I think for us, it was quite important that we revert back to the judgment of McBride versus the Minister of Police that was delivered in 2016, which confirmed the invalidity of aspects of the enabling legislation which establishes the IPID. And it specifically zoomed in on the independence, particularly the appointment, removal, and operations of the Directorate. The Constitutional Court emphasized the importance of the public having confidence in IPID for it to function efficiently. So not only must the institution be independent in its form, structure, and operations, but it's equally important for it to be seen to be independent, because if people don't see it as independent, that creates reputational problems. So Section 2066 of the Constitution envisages the establishment of an independent police complaints body to investigate alleged misconduct and offences committed by members of the South African Police Services. Our submission is that the proposed amendment before the Portfolio Committee, in addressing the independence of the complaints body should be founded on the following principles. The first principle is that there should be no political interference in the appointment and removal of the executive director. 2, the Directorate must have the freedom to receive and investigate complaints. The outcome, third, is the outcome of the investigation must result in a disciplinary hearing. Fourth, inasmuch as the Minister of Police is the cabinet minister responsible, the minister must play no role in the complaints investigation process and the outcome thereof. Last one is that the office of IPID is distinct from the police. So in terms of the appointment of the executive director, the new section 6.1 of the amendment proposes that the minister, with the concurrence of cabinet, shall appoint the executive director. 2, that the minister must notify parliament per notice within 14 days of the appointment. Under the proposed amendment, the minister requires agreement from cabinet of the appointment. The appointment is in essence made by the minister then. There is no parliamentary role save notification after the appointment has been made. The power to appoint the executive director vests in the minister and no one else. The Freedom of Expression Institute contends that these provisions fall short of the constitutional requirement of independent directorate. Political interference must be tempered to safeguard the independence of the executive director, and we submit that Parliament must play an active role in the appointment of the executive director. The Portfolio Committee must be given the role of dealing with the shortlisting of candidates, conducting interviews, and making recommendations for adoption by the President as head of cabinet. This process will ensure independence of the institution. And when it comes to complaints, Section 7, as amended, provides that complaints regarding disciplinary matters must be referred to the National Commissioner and, where appropriate, the Provincial Commissioner or Provincial Head of the Directorate for Priority Crime Investigation, Executive Head of the relevant Municipal Police Service. It is not clear why an independent structure should refer complaints to National or Provincial Commissioner of the Police and to what end. What would the purpose of that be? Section 2076 of the Constitution provides that on receipt of a complaint, the independent complaints body must investigate. The Freedom of Expression Institute submits that this amendment will severely undermine and interfere with the investigation. This amendment is an interference in the operations of IPID and impedes its independence. The Freedom of Expression Institution proposes that the Directorate should investigate all complaints received against members of the SAPS or municipal police services. On completion of the investigation, the report must be submitted to the Civilian Secretariat. In this way, IPID has the freedom to complete an investigation unhindered and ensures that the disciplinary processes do take place. In addition to investigating the police, the FXI submits that the remit of IPID should extend to the conduct of private security officers used increasingly by universities, colleges, and some government agencies. The aforementioned private security officers have in some instances similar powers to those of the police in the use of force. The outcome of the investigation should be submitted to the National Directorate for Public Prosecutions for further steps. And on the last point, it's on the remuneration and conditions of employment. Section 6.4 of the amendment provides that the minister must determine the remuneration, allowances, and benefits of the executive director. Section 23, as amended, makes provision for the minister to determine the remunerations and conditions of service of the investigators as well. The Freedom of Expression Institute submits that the executive director must have independence in determining the salaries of staff. Further, the determination of the remuneration and conditions of service ought to be removed from the office of the minister. The Directorate is not, we submit, either an appendage or part of the South African Police Services. IPID is an independent institution charged with investigating alleged police misconduct. It cannot, therefore, be the same police who have the control over staff remuneration and, by extension, the budget of IPID. And in conclusion, the Constitution envisages an independent police complaints mechanism. The independence of the complaints mechanism means operational, structural, and institutional independence. The current amendment fails to comply with the Constitution and the McBride judgment. In the FXI's view, it is extremely important that IPID not only be independent, but must be seen by the public to be independent so that it can have confidence in it. A strong and independent complaints mechanism will in turn result in an improved police service. Thank you.
Thank you very much, Samkelo. Honorable members, do you have something to say with regard to the presentation by Freedom of Expression? Honorable Ted Blanche.
Chairperson, thank you. I just want to thank the presenter for the presentation. Freedom of expression is quite important in our democracy, and I think it's good to hear their input also. So thank you very much again.
Thank you, Honorable Ted Blanche. Honorable Gomba.
Thank you very much, Honorable Chair. We want to thank the presentation and the submission. Thank you very much, Honorable Chair.
Thank you, Honorable Gomba. Thank you, Mr. Mkine. We take note of your presentation. We'll also start with a detailed one. Honorable Shekima.
Yeah, Chairperson, let me apologize that I cannot concentrate. I've had news early hours this morning that our Member of Parliament, Christopher Sibisi, passed at 6 o'clock this morning. But allow me to thank the colleagues for their presentation, and we appreciate it. And yes, indeed, we will do what is in the best interest of IPID. Thank you very much, sir.
Thank you very much. Condolences, Honorable Shekima. Condolences to your party.
Thank you.
Thanks very much, Freedom of Expression. Thanks very much, Samkelo, for your presentation. We'll interact with your presentation as we process the IPID bill. Thanks very much. Is IPUSA ready?
Speak. Honorable Chair, we are here and ready.
IPUSA, okay. Can you continue, please?
Thank you very much, Honorable Chair. The technology has not been kind to us this morning, and we really appreciate your patience in this. we are here now. Honorable Chair, IPOSA takes this opportunity and thank you for inviting us to make inputs to the IPID proposed amendment bill 21-2023. The objectives of the IPID Act, amongst others, is to ensure independent oversight role of the South African Police Service and Municipal Police Services conduct, to provide for impartial and independent investigations of identified criminal offences alleged committed by members of the SAPS and the MPS, and make disciplinary recommendations in respect of members of SAPS and MPS resulting from the investigations conducted by them. The above-mentioned statement empowers the Directorate to act against any member of the SAPS or MPS who have acted against the provisions of the IPID Act criminally, and to make recommendations to SAPS in terms of the disciplinary regulations of the SAPS or municipal police disciplinary regulations without fear, favor, nor prejudice. Firstly, this act directs that the Directorate functions independently and impartially from SAPS and MPS, and demands that each organ of state assist the Directorate to maintain its impartiality to perform its functions effectively. Honorable Chair, IPID will never be independent from SAPS, so long as they report under the SAPS Executive Authority. Secondly, they are easily coerced by SAPS not to act impartially or independently against certain members who are viewed by the SAPS or Executive Authority as their blue-eyed boys and girls. In short, they are not consistent in the application of this act. There is a lot of collusion going on against the SAPS, amongst the SAPS, IPID, and its executive authorities when it comes to whom discipline in the SAPS, MPS should be applied to. If we want IPID to be independent and impartial, let them report to a different minister than the one the police report to. There is a serious conflict of interest here. Herein under are our inputs to the IPID amendment bill. Honorable Chair, the definition as in section 1G, where it states the program manager, IPOSA don't think it's correct to define that, as this is structurally a structural position. There can be many program managers in an organization. We would prefer and advise that we be specific in defining the relevant post title as it appears on the organizational structure of the IPID. Two, the amendments of Section 7 of Act 1 of 2011. Section 7 of the Principal Act is hereby amended. I'm just quoting there. B, by the substitution for the subsection 6 of the following subsection. The National Commission, close quote. Our submissions, this is the stumbling process which is dependent on police management performance. We submit that the National Commissioner is the only authority to receive such and record the recommendations as such. Secondly, IPID investigation is only concerned with finding if there is or was a misconduct by a police officer, and if so, it recommends further action to be taken by SAPS or municipal police. This process is defeating by itself. The disciplinary process defined to be undertaken internally by colleagues must be changed to be independently done. There are hundreds and thousands of internal disciplinary cases in the SAPS, and there is no formal structure established dedicated to this. It does not work. In professional organizations that protect the conduct and behavior of their practitioners, such associations are the only independent structures which are supposed to be impartial. We suggest the IPID Act must have the establishment of a professional police association or an ombudsman to give relief to members of the service or public who are let down by IPID. International benchmark supports that. On 3.6b, I to 5, is it 1 to 5, and C may fall off if the above is considered especially where senior managers, police officers are investigated and recommendations are made for disciplinary process. This may, however, require the revision and amendment of the SAPS regulations on discipline. The same may be for municipal or for municipal police services. Section 8 of the Principal Act is hereby amended, and the amendment of Section 22 of Act 1 of 2011 and 12. Now, the Section 22 of the Principal Act is hereby amended. 4 to 5, not in support. We are not in support of establishing vetting officials everywhere. It is understood that the frustration of delays in completing vetting by the crime intelligence, it is up to crime intelligence to think innovatively out of the box. There is no way they can do vetting for all institutions. Sometimes we use the services of SSA, and if they are overburdened by requests of vetting, they may at some stage have to seek the assistance from the SSA. Either both technology and human interventions or temporary appointments of vetting consultants who are only paid for the work they are given, a national and provincial panel vetting consultants. Amendment of Section 24. The Principal Act is hereby amended. A, by the insertion in subsection 2 after paragraph B of the following paragraph. B, the taking of buccal samples in terms of the South African Police Act. It is not clear whether IPID intends to take buccal samples in their investigations. We don't know what investigative mandate and specialties IPID must have, like criminal record and forensic science investigations. The assertion here is that we are building a full capacity IPID investigation of criminal matters against the police or committed by the police. The use of investigations in the IPID Directorate must be explored to avoid ambiguity. The section refers largely to forensic science investigations, which is not a mandate for IPID. Let's check. If that is so, IPUSA wants to revert to the initial cabinet decision that all legislation must be costed before being signed into law by the president. Our argument is that forensic science investigation is a mandate intended for IPID due to its independence. We are employing that they must at least have a centralized forensic science laboratory for all the different focus areas such as biology, chemical, etc. Or do we prefer IPID to use private laboratories for analysis instead of SAPS resources? If the legislation is passed, we should expect an IPID infrastructure plan, which will include laboratories. Maybe that is good, but IPUSA don't think it was the intention of the clause. I've taken note of the inputs which are made by previous speakers, Honorable Chair. If you remember, I think somewhere in 2011, when we moved away from ICD, we had complaints that ICD does not have sufficient powers to play an oversight role over SAPS. We then moved into IPID, and we said IPID is going to be given enough authority and power to deal with the challenges our citizenry are experiencing from the South African Police Services conduct. Today, we are still complaining about the same issues. And if I remember or recall very well about the discussions that took place then, we even indicated that there is only one way of really giving the power and authority to the IPID for it to be seen to be independent and to act impartially, and allow them not to resort under the auspices of the executive authority where the South African Police Service and the MPS report to. So, Honorable Chair, here we are again today. We are sitting with the same problem. IPID is really in trouble. The issue of the human resources, the issues of support that they need from the South African Police Services, the dockets that they're having are mounting. And sometimes here you even are confronted by two scenarios. The issue of the members who, in terms of command and control within their department, you find them, some of them reporting to the current, ED, and some of them still very loyal, very much showing loyalty to the previous ED. These issues need to be looked at because they are defeating the purpose. They are making IPID not to be impartial and to be independent from doing its duties. The short part of it from IPUSA, we thank you very much, Honorable Chair, for giving us this opportunity to input here.
Thank you very much. Can we see your face?
And like I said, I want to try and do this, Honorable Chair, because we're using some other microphone. Your video is stopped. Okay. I don't know how to do it, Honorable Chair. Oh yeah. Here I am, Honorable Chair.
Okay. Thanks very much. Thank you.
Thank you very much.
You. We just want to connect the voice to the person, to the face. Honorable members, there is an input from IPUSA. Do you want Honorable Terplanch?
Chairperson, thank you. I want to thank the gentleman first for showing his face. It was quite good to see him. But I think just thank you again to another very valuable input. And, it's good to see that, the organizations in the police are supporting and that they are quite serious about arriving at, something that is going to work for the good of all the citizens of the country. Thank you.
Thank you very much. Honorable Boni Marekwa.
Thank you, Chairperson. And just to note, I'm just raising my hand to note the presentation by IPUSA. We appreciate their time for coming, all those who have presented for now. Thank you, Chair. We'll further, like we said earlier, we'll deal with everything in the coming week or coming days. Thank you, Chair. Bye.
Thank you very much, Honorable Marekwa. Okay, let's continue. Is Mary Haas in the house?
Chairperson, excuse me, if I can come in. Mr. Haas is on the platform, and then Mr. Haas will be followed by Commissioner Nissen from the South African Human Rights Commission. We managed to secure his attendance at 10:30-ish.
So who must start?
Mr. Haas, please train.
Okay. Mr. Haas. Mr. Haas.
Oh.
Yes, continue.
I am small video. I'm battling. Hi. Can you hear me now?
Yes, I can hear you.
Okay, let me try the video. Start video. It's just refusing to start the video. Ah, sorry. I don't know what's happening now because my camera's on. Would you like me to proceed in the meantime and not waste time fiddling with the video? I don't know why it's giving me a problem. I have told it to start and it's not starting.
Please continue. We'll deal with the video issue later.
Well, can I deal with it later? Let me continue. Well, good morning, everybody, Honourable Chairperson and members, and thank you for inviting me to make this presentation. I have put an outline in PowerPoint in writing, but you don't need to. It's just for dissemination 2 members, it helps me to organize my time. I start off, I'm a social scientist, a retired academic. I'm a highly experienced researcher, and the research includes policing, especially in the 1990s. I'm a qualitative researcher. I have a huge network in this province because I'm an anthropologist who in the 80s was sitting in shebeens and going to weddings. And then in the 90s, I started working with the late Frank Dutton and his partner, Wilson McGardler, and one thing led to another. I had a huge network of police coming to my office then, and I worked with the Goldstone Commission Investigative Task Unit. I did formal research on policing, put out a report, conference papers, etc. So there's a history there, and it's continued because what I've also been doing, the other part, the experiential part, is that I follow up cases for people. This has never gone away. People come to me and they want help, and I follow up with the police. And that's so I get information all around. Right now, I'm getting police from networks in other parts of the country even. So I get first-hand information. Right. Now, there's a crisis in policing at the moment, and IPID is not dealing with it. Since 2009, there's been an increasing lack of accountability. And I know this because I write to the police and other government departments. And increasingly, there's no responses, no transparency, increasing secrecy. There's also been an increase in brutality, including deaths at the hands of the police and torture. And from my own experience, and this, I'm told the Durban office is probably the worst in the country. This is by IPID from other parts of the country. But I mean, I could give you case after case where we have we've helped IPID to get supplementary statements, the medical evidence, severe torture, death by tubing, and no prosecution. Look, obviously the prosecuting authority should perhaps be guiding them better, like they should be with the police, as was the intention with the ITU and the Goldstone Commission. I mean, in the 2021-22 year, a total of 633 deaths occurred at the hands of the police in custody and as a result in police actions. Hardly any prosecution. The politicization of policing has increased. You only have to look at media reports in the last 10 or 15 years. Constant interference of the minister in operational matters, which is completely unconstitutional at the expense of neglecting policy issues. This is why July 21 happened. At one police station in urban Durban, several dozen police members refused to lift a finger because they were loyal to Jacobson. They even intimidated members who wanted to work. Remember, we've got elections coming up next year. There's also ministerial interference in IPID. There was an attempt last year, which I think is on record with the parliamentary committee, where the minister decided to appoint a former Hawks member to head the Durban office. It was realized then the member actually had a criminal case against him. He got to Durban, he was sent away, I was told, by an IPID. Okay, there's a need for independent oversight, and this bill does not provide it for reasons I will go into. I quote and I won't read all this now, I quote the United Nations Handbook on Oversight about how you can't rely on state institutions to provide oversight. They see a complementary process as completely independent oversight, and within the police, obviously, that's the point. The police should be investigating. There's an inspectorate. They're complementary processes. The interesting research commissioned by the European Human Rights Commission found 5 crucial criteria for independence. No institutional or hierarchical connections between investigations and those under the investigators and those under investigation. There has to be a complete distancing, including from the hierarchies managing the police and the hierarchies managing the independent oversight. there must be an adequacy, there's a capacity to gather evidence which can either show lawfulness or unlawfulness. There has to be promptness in investigations. Well, that's not happening. There has to be public scrutiny, transparency, and there has to be victim involvement. IPID does not meet those criteria. I won't waste time now giving you case after case after case where it does not meet the criteria. And there was one case a couple of years back where it was operational police burst into a rural homestead in the middle of the night and just shot a man dead with a rifle in front of his mother, his girlfriend, and his children. Cleared some of the crime scene, did not report to IPID. When I tried to get IPID, I couldn't even get there. It took me a couple of hours to track someone down. Okay, no, and I don't know what's happened to that case. There was clear evidence, procedures weren't followed. I had to explain to the investigator what he should be doing. I don't understand. Right, now how do we get institutional independence? Now, a modern state, we're a democracy, bureaucracies are supposed to operate independently. You know, independence means governing norms about loyalty. The loyalty is not to a person, it's to your institution. An institution is a relationship of norms, you might say, people adhere to. And those norms are impartiality, record keeping, transparency, and your loyalty is to your organization, which is completely independent of a political organization. If it's the civil service, which is the police, which IPID is. This is opposed to what we have in South Africa at the moment. And these, I'm quoting top sociologists here, which is standard accepted. In a sense, it's sociology 101. Bureaucracy as opposed to patrimonialism. Patrimonialism is where you have loyalty to the person who appointed you, usually a politician or someone who gives you an economic advantage through it. It's a patronage system. It's a nepotistic system. That, unfortunately, has taken over in most of our government institutions in the last 15 years. It is not what's in the Constitution. Chapter 10 of the Constitution is very clear about our government departments and how they should work in terms of proper bureaucracies. Transparency, public involvement, you can read chapter 10. Section 197 specifically excludes political partisanship. Right, now, our Chief Justice is very clear, strictly about appointment criteria. There should be no executive involvement in any appointments to the public service. Right, now, what we are seeing now, look, what I'm saying applies to any ministry, any minister. It just happens that the present minister is a classic example of how wrong things can go, given the fact that he is behaving unconstitutionally. I mean, how can a person who tells the police to shoot to kill head an agency which is investigating those killings? Is that just not such an obvious conflict? Conflict of interest. He even signs the IPID report as a general. He's not a general, for goodness sake. I don't know why he's got an obsession with being a general. You know, it provokes the image of jackboots and goose steps. Okay, so it's not what the Constitution, it's not what the negotiations envisaged for our society. The police were to become public friendly. That's why there was a demilitarization. Now, first of all, this bill wants to remove the public service. It wants to place everything in the hands of the ministry. Now, the Constitution is very clear. All government departments fall under the Public Service Commission. There can be no negotiating about that. In fact, you'll see in the Concord judgment, there's an order referring to what the Public Service Commission must do and what the police must do while they process information. Now, I think it's an absolute disgrace and contempt for the Constitutional Court that legislation hasn't been passed 6 years later. So, staffing matters. Let's look quickly at staffing matters. The Executive Director. The judgment is very clear. You know, it has to be independent. But the Minister is now, in this latest draft of the bill, appointing the Executive Director for a period of not less than 7 years. It's not all, up to 10 years. No reference, the reference to any removal of this head has been removed from the current legislation. How do you know, what I'm grappling with is how do you then remove a person who is incompetent? Who has oversight of IPID when it's incompetent and defeating the ends of justice, which it is in some cases? We need the criteria in the legislation. It's not enough to say it's you know, for the Executive Director, we need details about qualifications, but also about experience. You know, when the police report, I was working with the police reporting office since it was started before 94, and the outgoing police reporting officer went nationally, said to me, well, who did I think should be a good replacement? I actually suggested Advocate Bassoni. I thought he had the appropriate experience. Oh no, said the guy, no, we're looking for someone more junior. Well, they got someone more junior, and it turned out he was under investigation by the Bar Council, and it was downhill from then on. Right, so there has to be strict criteria. Historically, there have been prosecutors and advocates with court experience heading IPID. We had a position that the head of IPID in Natal was a police general from one of the most problematic police stations in the province. How can there not be a conflict of interest? That was the head of the Durban, or the KZN office. You need a simple law degree isn't enough. You know, a lot of students get through basic law degrees by the skin of their teeth. And if they don't have experience, they've got to have competence, they've got to have experience. It's got to be. As for staff appointments, very serious problems in both the bill and current law. Section 12 of the bill removes the provision that applicants have to have a grade 10 qualification, a school, basic matric qualification, not necessary anymore. The criteria are vague. They must be spelled out in detail. We have now people who were very junior in the police, no research, no experience in investigations. You know, like a media liaison officer who was just a very junior person investigating senior police. I mean, the senior police are probably going to run rings around them because at least they've been trained, even if they are corrupt themselves. You know, good training and intelligence doesn't outrule corruption, obviously. We know that. That's a human frailty. I mean, these are current problems. They come from ranks. We don't know where some of them come from. You know, why? How do you get to be a supervisor in IPID? What qualifications do you have? Serious problems. I deal with this because I deal with investigators. I deal with management. You can't get through to them. They don't reply to emails. They don't reply to phone calls. And I do it on behalf of victims, like I do with the police, because the police don't report back. Neither does IPID. They're supposed to, in terms of victims' charter, reply back. They don't. So, and of course, there's been nepotism all along. You know, I'm part of a medical rights group that we have a former head of law, we have a top pathologist. We offered to train IPID years ago. They just ignored it. Okay. Security and qualifications there's no mention of qualifications verifications. That's essential. That's what the Public Service Commission has started doing. I'm not sure why they want to remove state security. I mean, we know that state security has problems. Those were highlighted in the Mufamadi panel reports. And again, there's got to be a return to civilian oversight. That hasn't happened yet. But even with all the shortcomings in intelligence because it's supposed to be state security, does it? It's still an independent body as opposed to the director. What qualifications does a director have to do a security clearance? So again, this is why we have to keep the Public Service Commission in, and we have to keep the state security in. Let me go through very quickly the type of staff you want if you want to be independent. And I've discussed this, I've discussed it with senior people at some stage. In IPID itself, you've got to have experience in forensics. You've got to know about basic medical forensics. Experience in ballistics. You can't rely on the police if you're investigating. Then somebody's got to know something about ballistics, especially crime scene securement. Often crime scenes are fiddled with before IPID gets them. They must be at the crime scenes before there's any interference with the crime scene. And they need forensic auditing skills. I mean, why are these not spelled out in your what you want in the way of staff? Investigations, they're giving themselves increased powers. I mean, investigating the National Commissioner, it's ridiculous. I mean, there's a clause in the SAPS Act. That's the prerogative of the President to establish a judicially headed. So you could have someone who hasn't had any training going off and doing investigations, provincial commissioner, this one, that. National Commissioner, the SAPS Act is very clear about setting up a body to investigate, headed by a judge. Now listen, we know, and I mean this is on record with Parliament, with the President, we know that the Minister wants to get rid of Masemola. We know that the deputies to Masemola take instructions clearly. He's appointed 2 of them. The others were appointed by Zuma and Matshuya. Yet the National Commissioner has accounting responsibility. So it cannot investigate. IPID cannot. This is a clause put in, I think, to please the Minister. IPID investigators do not have to take vocal samples. Our medical rights group had severe problems with the police taking samples because there are medical ethics, medical laws about human tissue. There's no need. I mean, they can go off if they think they need one. They go off to the nearest clinic and a nurse will take it. Any physical specimens are supposed to be taken by medical. Worst of all, though, is this new power to subpoena people. I mean, what they want to do are the sorts of things that happen in court procedures. This is open to gross abuse, especially for a politicized, opaque, lack of transparency body, lacking totally in accountability, with inadequate investigation skills. So, finally, I'm whipping through this quickly. Some more of this is in writing, but I can provide you with fuller details if you need. I have extensive notes. I've dealt with some of the main problems. Look, there are others which are completely unclear to me about why they're there. But I've dealt with the main problems. I've made it obvious that Bill can't give independence in its present form. I thought, and this is why I said in my initial reaction to it to Parliament, it's actually an insult to people's intelligence to try and claim that this gives independence, because when it is so patently obvious it's not giving independence as required by the Constitution, as pointed out by the Constitutional Court. I'm currently experiencing serious problems with IPID. You will hear more about that. One of them includes alleged defeating of the ends of justice by IPID staff members, which have had serious consequences for very competent, hard-working police members and actually risked their lives. The cases were thrown out of court, and this cover-up by IPID, deliberate cover-up, was revealed in an affidavit before the court when the case was thrown out by the judge after years of wasting these policemen's time because there was no evidence. This was recent. We have to go back to the drawing board and look at how other democracies deal with independent oversight. There's a lot of clues out there. You know, the example, the United Kingdom, which has very few deaths at the hands of the police, but they led to a complete provision of oversight. It has a body, which is a panel, democratically appointed panel of experts, which oversees investigations. I mean, strictly speaking, we could have a judicial oversight body here, and a far more opaque appointment of people. We could have a board overseeing. There's all sorts of options. We need to go and discuss this. I mean, the European Commission has the countries there have a variety of ways of trying to ensure a proper independent oversight. Some of the best ones are the Scandinavian countries. Scotland's quite good. Northern Ireland, the Dutch, they've all got, I mean, some have provisions in which when there's an appointment by Parliament, there has to be a majority, not just a simple majority, but a kind of 2/3 majority or consensus about who gets appointed to head. There have to be provisions about criteria for removing people, including the head. Okay, finally, there's been no progress in policing. I wrote up on July 21. If you've read, now please do read the Sandy Africa Committee chaired report about the gross inadequacies of policing. I mean, the fact that the minister didn't resign, which happens in a democracy, let alone, I mean, he didn't even call the soldiers in time to stop what happened. It's a disgrace. He should be fired. Nothing seems to have changed. There's an urgent intervention needed. I think there needs to be the appointment of some judicial person just to oversee what IPID is doing. As an emergency, we have elections next year. We have a politicized police, very politicized police, quite apart from the corruption and nepotism. If the minister is giving directions to deputy commissioners about what to do, how much more politicized can you get? We have elections next year. Please, we need to act urgently, starting with throwing this bill out, going back to more consultation and a better piece of legislation. Thank you very much for listening to me. I shall try, I think everybody knows what I look like, but I shall try to start the video, but it's just not starting, and it's not telling me why it's not starting. I'm terribly sorry about this. I really am doing my best. Okay, thank you very much for listening to me and for the invitation.
Thank you, Ms. Dihas. Thank you very much for your presentation. Anything, honorable members? Honorable Marekwa, Honorable Terplanch, Honorable Marekwa.
Thank you, Chairperson. We note the presentation from Mr. Haas, and she must just watch her video. It might come on when she's not presenting. Thank you.
Yeah.
Thank you, Honorable Terplanch.
Chairperson, thank you. I also want to thank Ms. Haas for her presentation, and obviously that will be considered, also with the rest when we are going through our exercise. Thank you once again.
Thank you very much.
Oh, wait a minute. Not happening.
Thank you very much, Ms. Diaz. Everything will be considered when we deal with the report. Thanks very much. The next presentation will be from South African Human Rights Commission. Am I correct, Nicolette?
Hello, PC. Hello.
Hello.
Hello, good day, sir.
Yes, how are you, Kaya?
It's Chris Nissen here.
Oh,
How are you,
okay.
my person?
I'm fine, and how are you?
Good, Chairperson. What time are we on for? We on for now. May I come in if you don't mind, Chairperson, because Kwanele, Dr. Pagati, will do the presentation.
Yes, continue. Continue.
Thank you so much, Chairperson. May I just greet you, Chairperson, Honorable Chairperson, and members of the Portfolio Committee. Thank you for this opportunity for us to make an input into the legislative process around the proposed bill. And I have Dr. Pagati, but also Fatla Adams, who is our parliamentary liaison officer. And I just want to say thank you so much, Chairperson, for giving us this opportunity. May I then ask Dr. Pagati, who's here, and Fatla, who's also here, just to take you through. You have received our presentation, and I think that you can see from the presentation where we come from in terms of our specifically from the NPM, the National Preventive Mechanism, the OPCAT, but they'll take you through it very briefly. Thank you, Chairperson. I really appreciate this opportunity. May, with your permission, Chairperson, honorable members, and over to Fatla and Dr. Pagati, if that's in order with you, Chairperson.
Thank you. Thank you very much. Mr. Pagati.
Good morning, Honorable Chairperson, members of the Portfolio Committee, and colleagues who are joined on this platform. I am Gwanele Bhagati from the South African Human Rights Commission, responsible for the National Preventive Mechanism. I'll be taking the Portfolio Committee through our presentation, and I've got a few of my colleagues who have joined the platform as well. Ms. Fadla Adams, there's Kaya, as well as Katlago Mulapo, who are all working within the Commission. With your permission, Chairperson, I would then proceed to the next slide, but also I'll switch off my video and then start with the presentation. Thank you.
Continue.
Thank you, Chairperson. I'm just trying to find the controls for the slide. Okay. Honorable Chairperson, the South African Human Rights Commission is grateful to the Portfolio Committee for the opportunity to make both written as well as oral submissions in relation to the IPID Amendment Bill, as it is enjoined to do so by Section 13 of the SAHRC Act, as well as South Africa's international obligations, including the optional protocol to the Convention Against Torture. We have had the benefit of following earlier submissions and would like to submit our support for most of the salient points, substantive points raised therein. And for instance, one of them being the IPID's ability to initiate relevant legislative submissions and processes and not necessarily rely on the civilian secretariat. And we equally take note of your observations, Honorable Chair, that you raised in the beginning in relation to Clause 4. There was also a point that was raised by the content advisor, Nicolette, in relation to the 2013 Act, which indeed predates the ratification of the OPCAT. And we are also pleased to note that the Portfolio Committee will be seeking legal advice on the implications of the OPCAT in relation to the IPID legislative framework. Notwithstanding the recommendations anticipated from the parliamentary legal advisors, it is imperative, Honorable Chairperson and Honorable members, that IPID's independence be strengthened, and this would support the OPCAT compliance. Honorable Chairperson, you asked a question to Mr. Sean Tate, who was the first speaker this morning, in relation to the appointment process, given the fact that IPID is not a Chapter 9 institution. And we would like to submit that, notwithstanding that fact, insulation from undue political interference demands that Parliament plays a role in both the appointment as well as the dismissal process. We submit that this should be an open and transparent process, open to all qualifying persons. This also speaks to the issues around the qualifications that were raised by previous speakers. We are not arguing for the total exclusion of the minister, but argue that the minister would possibly then sign off and appoint the relevant individual following the parliamentary process. And institutions such as IPID should also be guided by the Paris principles insofar as issues around its operational, structural, financial, and institutional independence. And linked to the point above is the fact that the executive director would obviously account to both Parliament and the minister as the functional political head. Now, I will go into the presentation, the chairperson highlighting the three substantive issues that we have identified in the bill, and largely speak about the national preventive mechanism following the ratification of the optional protocol to the Convention Against Torture, which was raised by the content advisor earlier this morning. Now, on this slide, Chairperson, we do take note of the purpose of the amendment bill, which seeks to amend the Principal Act to provide for the Directorate's institutional and as well as operational independence, but also to provide that the Directorate must be independent, impartial, and must exercise its powers and functions without fear, favor, prejudice, or undue influence in order to give effect to the judgment of the Constitutional Court in the case of McBride versus the Minister of Police and another, and also amend the provisions relating to the appointment of the Executive Director and the Executive Director of the Directorate. And given the purpose of the bill, Honorable Chairperson and Honorable Members, the substantive pillars of our submissions are threefold. Number one, the extension of IPID's mandate to conduct preventive visits to police detention facilities to give effect to its obligations under the optional protocol to the Convention Against Torture, but also to note the implications of the OPCAT on the independence of the national preventive mechanism as a whole, and exercise prudence in relation to the appointment of the executive director, but also conditions of service and remuneration of the executive director as proposed by the current iteration of the bill. But lastly, the implications of the OPCAT on IPID's independence, specifically relating to the remuneration and conditions of service of investigators. These are all linked to IPID's functional, operational, institutional, legislative independence, Honorable Chair. By way of an introduction into the optional protocol to the Convention Against Torture, which I will refer to colloquially as the OPCAT, the Republic of South Africa completed its ratification process of the OPCAT on 20 June 2019. Thereafter, the OPCAT came into force for South Africa on 20 July 2019. Now, importantly, Honorable Chair and Honorable Members, under the OPCAT and specifically Article 3, the states parties are obliged to establish, create, or designate monitoring bodies or monitoring institutions responsible for regular visits to places where persons are deprived of their liberty, to strengthen the protection of such persons against torture and other ill treatment. And as a complementary process, This mechanism is obliged to also follow up on the implementation of its recommendations following its visits to various places of deprivation of liberty. And now in this slide, Honorable Chair, you see the rationalization of the National Preventive Mechanism arguing for the NPM in relation to South Africa's international obligations, where number one, the OPCAT in its preamble argues for the creation, or rather argues for a differentiated approach insofar as preventing torture and ill treatment in places of deprivation of liberty through non-judicial means, but also this mechanism must be part of a systemic analysis of complaints, or observations of issues that emanate from places of deprivation of liberty. And another pillar that underscores the National Preventive Mechanism is the fact that it is a preventive and a proactive mechanism that is not driven by any complaints. Bodies that constitute the National Preventive Mechanisms are obliged to go into these facilities on a proactive basis regularly without any complaint being raised with such institutions. And we argue here, the fourth pillar being that there is a possible cost benefit to the fiscus over time by reducing or potentially reducing the civil claims against the state, as well as the reduction of possible human rights violations emanating from various places of deprivation of liberty. And importantly, the National Preventive Mechanism is obliged to work collaboratively to cooperate with the different institutions in order to address any systemic issues that are identified. Now, Honorable Chair and members of the committee, at the time of ratification of the optional protocol to the Convention Against Torture, South Africa did not make any or did not invoke the provisions of Article 24 in relation to its obligation to establish a national preventive mechanism. Article 24 allows states parties to make a declaration postponing the implementation of their obligations for a maximum period of 3 years. The rationale from a South African context was that there is already consensus that there are a number of bodies that are responsible for, in one way or the other, responsible for playing oversight over places of deprivation of liberty. And as such, these bodies were then identified to form part of South Africa's cooperative national preventive mechanism. And I will mention these institutions quickly, Honorable Chair. One of them, which is of relevance to this portfolio committee today, will be the Independent Police Investigative Directorate, the Judicial Inspectorate for Correctional Services, the Military Ombud, as well as the Health Ombud. And on top of that, the Human Rights Commission was then given an additional responsibility over and above its functional role to also coordinate this national preventive mechanism. As it was mentioned earlier by one of the speakers, earlier this year in February and the beginning of March 2023, we also received a visit of the United Nations Subcommittee on Prevention of Torture, which is responsible for monitoring the implementation of the OPCAT at a global level. The SPT is also obliged to work collaboratively with states parties as well as national preventive mechanisms. And it also has an obligation to advise national preventive mechanisms and states parties. Now, the last point on this slide, Honorable Chair, is the fact that during the ratification process and approval of the establishment of the National Preventive Mechanism, a proviso was made that legislative amendments will be necessary to give effect to the OPCAT prevention mandate, particularly for the four institutions that are mentioned here, JIGS, IPID, the Military Ombud, and the Health Ombud, so that the prevention element is introduced to their legislative as well, operational as well as institutional mandates. Now, I mentioned places of deprivation of liberty, Honorable Chair and Honorable Members. Just to give an example here, these places include police stations, immigration detention facilities, correctional centers, psychiatric institutions, and so on. But one most important point to underline here is that these places include any place where a person is unable to live at will. It also includes, you can see at the bottom of the slide, that these places also include modes of transport, transporting arrested persons from one place to the other, or detained persons from one facility to another. I'll skip that slide. It speaks more broadly about the functions of the National Preventive Mechanism, and move to the next one, which also speaks about the functions of the Human Rights Commission in relation to its coordination role. Most importantly, to report on behalf of the entire National Preventive Mechanism before Parliament, but also the United Nations Subcommittee on the
Portfolio Committee, EPIT.
Kwanele,
Yeah,
Mr. Kwanele. Mr. Kwanele, please mute. Continue.
Thank you very much. Thank you very much, Honorable Chair. Here on this slide, I was speaking more broadly about the functions of the South African Human Rights Commission in relation to its coordinating function in the National Preventive Mechanism. And most importantly to highlight here is to report before Parliament, as well as the United Nations Subcommittee on the Prevention of Torture in relation to its functions under the OPCAT. And on to the next slide. Here, some of these points are relevant to the case of IPID, which the second one and the third one that I will highlight here would be the slow progress to attain independence by NPM institutions, as well as budgetary certainty. And this speaks to the issue around resources in relation to giving effect to the OPCAT mandate. As I am aware that currently the NPM mandate within IPID is unfunded, and it requires budgetary considerations, but also proper costing so that it gives effect to the OPCAT compliance. Now, the recommendations that the Human Rights Commission makes, Honorable Chair and Honorable Members, is that the committee should consider the potential adverse implications on the NPM's independence and compliance with the optional protocol to the Convention Against Torture if the proposed provisions of Clause 4 are accepted in their current iteration. This relates to the argument or the submission that there must be a parliamentary role in both in the appointment as well as the dismissal of the executive director of IPID. But also given the fact that Parliament designated a multi-body national preventive mechanism inclusive of IPID, the committee should respectfully consider extending the mandate of IPID as an NPM institution to be able to conduct preventive monitoring in conformity with provisions of the OPCAT. Now, the point around the independence of IPID as well as the ED's independence, both in terms of operational and functional, this needs to be addressed to enable IPID to fully function as an NPM institution as envisaged in the OPCAT. The point raised by Honorable Chair, the point raised by the content advisor in the morning around the fact that the 2013 Act predates the OPCAT. There are some, I think, options that could be considered by the Portfolio Committee in relation to this, while a holistic legislative framework for the NPM is being explored. One of them could, to support the proposals that have been made here in relation to the appointment process of the executive director, that would not have any implications insofar as the holistic legislative framework for the national preventive mechanism. And also we recommend that, as argued by Sean Tate in the beginning, that the definitional elements insofar as the definition section should include the national preventive mechanism and what the national preventive mechanism is. Recommendation number 2, considering that the bill seeks to entrench the institutional as well as operational independence of IPID, the committee should consider an open and transparent process for the appointment of the executive director, to include a process for nominations and or applications from suitably qualified persons. And here I would like to underline, Honorable Chair, that IPID is not a Chapter 9 institution. However, one of the presenters earlier argued for a balanced approach, and in our view, that should be possible and address some of the shortcomings that have been identified. And then thirdly, in relation to clause 4, the provision around the remuneration as well as the conditions of service of the executive director should also be underscored and highlighted here, in the sense that they should not be reduced, nor may the allowances and other terms and conditions of office and service benefits be adversely altered during the term of office. And for consistency and to rule out any ambiguity, the appointment of the executive director should be fixed to a non-renewable term of 7 years. Alternatively, the committee could consider that the executive director should be appointed for a term of 5 years, renewable once, and obviously this will be based on performance. And that's where also the role of the minister, the functional minister, comes in insofar as accounting to the department is concerned. And to also eliminate any perceived or real conflict of interest, we argue for the inclusion of an exclusion criteria insofar as persons who are not eligible to be appointed as the ED, for instance, those that are employed in the police as well as the municipal police service. And also we recommend to the portfolio committee to introduce a procedure for determining incompetence and incapacity, a provision for a committee inquiry to assess the fitness of the ED with a threshold for removal. And we also recommend that further to the appointment process, the proposed substitution of Section 23 of the Principal Act goes against the real and perceived independence of the Directorate, given that the power to determine the remuneration and conditions of service of investigators still resides with the Minister. We respectfully submit that this power should reside with the ED as the accounting officer of the Directorate. Obviously, a proviso here would be the argument against ensuring that the conditions of service are not lower than those of detectives within the South African Police Service. And we then argue that the committee should consider an amendment that will ensure the executive director can determine the remuneration and conditions of service of investigators without undue influence or undue interference from the minister. And here there could be some lessons that can be extrapolated from the case of the Judicial Inspectorate for Correctional Services. Thank you very much, Honorable Chair and Honorable members, for your time. That would be just about it from the Commission. Thank you.
Thank you very much. Thank you very much for your presentation. Can I check with honorable members if they want to say something? Honorable Terplanch.
Chairperson, thank you. I want to thank Mr. Pakati for this presentation. obviously coming from the Human Rights Commission, that is very important, one of our important watchdog organizations. And thank you once again.
Thank you very much, Honorable Terplanche. And thank you very much, Mr. Pakati. It is now 11:05. The next presentation
Chair, if I might come in.
yes, Nicolette.
Chair, we have Dr. Johnny Cogger online from Kifuna Nkwazi, ready with his presentation. Chair, and just to note that Advocate Mike Potier from the Catholic Parliamentary Liaison Office is currently presenting a case in court, and he will not be available to join the committee. But Chair, we will try and reschedule him for next week.
Okay, so this will be the last presentation.
Yes, Chair.
Okay. Ndifuna kwazi.
Good morning, everyone. Just to confirm that I'm audible.
You are audible but not visible.
Not visible. Whoa. Not entirely sure how to resolve that. So if I may proceed without being visible, if that's allowed.
Pardon? Now members just want to see your face.
Sure. Excuse me. Perhaps if I stop sharing for one moment, there, and start my video. There we are.
Yes, now we can see your face. Thank you very much. Continue.
Yeah. Good morning, everyone. First of all, thank you so much for this opportunity to present. We do not take lightly the opportunity to input into legislative drafting process. It's I mean, as you live and breathe this in terms of your responsibilities, but as a member of public and as an employee of a public interest organization, we highly appreciate this opportunity. By way of introduction, my name is John T. Cogger. I'm attorney at an organization called Indifuna Kwazi. Indifuna Kwazi is an activist organization based in Cape Town. We combine research, community organization, and litigation in order to advance and protect well-located affordable housing in an effort to try redress the spatial legacies inherited from apartheid and colonialism. Unfortunately, in the course of our work in trying to advocate for housing for communities and households, we have encountered law enforcement in the scope of our work. And it's with that in mind that we have increasingly turned our attention towards the intersection between policing and housing, and the way that manifests, especially with vulnerable communities as they struggle for recognition, and also increasingly as people move towards the towns and cities, and as urbanization occurs, there's conflict between maintaining urbanization or regulated urbanization and housing needs. But before I get into the meat of our recommendations and our comments on the IPID amendment bill, I'd like to first just contextualize in more detail some of the examples of why we find it pertinent to engage in policing in a more substantive way. The first example is the tragic death of Mr. Dumisani Joko, who was a homeless man. He intervened during an altercation between a LEAP officer, Kati, and another homeless person. And unfortunately, in the process of that altercation, was shot in the face and was killed. In the aftermath of this tragedy, the city of Cape Town did an independent investigation. They briefed attorneys to investigate the matter, and there was certain internal disciplinary processes, and the Officer Kati was criminally charged, but the IPID wasn't necessarily involved in that process. The unfortunate murder of Mr. Joko made headline news in Cape Town, but as well as nationally. And if I can just read some of the titles of the articles, reflect a concern for the absence of accountability in the way that law enforcement conducts itself. So Mail and Guardian says Dumisani Joko, another census law enforcement killing. Cape Town News says Dumisani was shot without warning, witness tells the courts. And another one says Joko slain, homeless man remembered. And what these news articles reflect is obviously a deep interest in how law enforcement conducts themselves, and what type of accountability measures exist in order to hold law enforcement accountable for transgressions in the course and scope of their employment. Another perhaps more prominent example that we've regrettably encountered in the course and scope of our work is that of the illegal eviction of Mr. Bulelani Klolani in July 2020, where in the process of demolishing his home, the City of Cape Town's anti-land invasion units, accompanied by private contractors, arrived at his home in Interbeni, informal settlement in Khayelitsha, and then proceeded to drag him out of his home naked, and then even once he had managed to gain re-entry into his home, law enforcement officers demolished his home while he was inside. There were also a number of subsequent investigations into this act, but none of them were subject to the jurisdiction of IPID. It was also subject to litigation between the Human Rights Commission and the City of Cape Town, where the Western Cape High Court declared the demolition of Mr. Klolani and other communities' homes during 2021 and the lockdown restrictions unlawful and unconstitutional. So there's obviously a level of concern, from members of the public, communities, Chapter 9 institutions, civil society actors, as well as the media, and the way that law enforcement in the city of Cape Town conducts themselves. But what is illustrating about these examples is the absence of a clear channel in order to properly direct any complaints. A last example of our interaction between trying to advocate for housing and our encounters with law enforcement is that over the years, when law enforcement conducts various operations with homeless communities, they deprive tented communities of their homes and their personal belongings, and we have been forced to go to courts to seek spoliation orders to get return of people's personal belongings and their tents, and in all of those circumstances, the Western Cape High Court has upheld the application brought on behalf of communities, which again just reflects, this worrying sign that law enforcement in the city of Cape Town is operating outside of the law, and the absence of other mechanisms to hold them accountable for their actions, outside of the judicial process. We've been forced to run to the courts as our only optimal opportunity. But what all of these examples demonstrates is a constant fear faced by marginalized communities, such as the homeless and the landless, like Mr. Bulelani Tloloni, of the actions at the hands of law enforcement officers. But these are not isolated examples. Over the past 3 years, countless members of the public have come to our offices and raised alarm of harassment, of disproportionate use of force, and illegal evictions at the hands of law enforcement officers. So we obviously are concerned about this increasing trend, and which is why we made a comments to the IPID amendment bill. And so what's the problem? So we've identified the problem that exists in Cape Town as a definition or an understanding of municipal police services within the principal acts. So the city of Cape Town has 2 municipal police services. The first is Metro Police, and this falls within the jurisdiction of IPID, as far as we understand. But then the second is law enforcement and the anti-land invasion unit, which falls under the oversight jurisdiction of what is called the Civilian Oversight Committee. So law enforcement is a directorate held under safety and security, and the anti-land invasion unit is a directorate of specialized law enforcement officers established through the city's human settlements departments, and this is intended to prevent unlawful occupation, and so what we see here is effectively two types of municipal services, police services, which ought to be playing the same role, falling under different jurisdictions. And what's interesting is that the Civilian Oversight Committee has been, it is authorized. The city has, in essence, done nothing wrong in establishing this oversight committee, but it exists to investigate conduct and complaints against the City Traffic Services Department, law enforcement, and Metro Police. The committee is constituted of civilians who receive a nominal stipend from the municipality and do oversight work on a part-time basis. So notwithstanding this mandate, there exists a lack of degree of transparency and and accountability because their reports are not made publicly available. Moreover, the anti-land invasion units has no separate accountability mechanism within the Human Settlements Department to receive complaints, and there seems to be some confusion even about the operation of the city's ombudsman with regards to being an independent, impartial, unbiased, and non-prejudicial service. And so, from what we see, is a lacuna in the way that municipal police office services operates. There's no independent complaint oversight over this function. There's no impartiality. I think it's worrying that civilians who sit on the civilian oversight committee receive remuneration from the city itself. So that speaks to it not being completely independent, and a lack of transparency and accountability in terms of releasing of reports. And so our recommendation is very simple. It's law enforcement and any specialized units established within a municipality to either protect itself from land invasion or to enforce bylaws where they play a municipal policing function or to fall within the ambit of IPID. This would close the gap between a difference between the Metropolitan Police and law enforcement, and having dual and parallel oversight procedures. And this recommendation is consistent with the IPID directive as reflected in Section 2 of the Principal Act, which sets out its mandates to provide for an independent and partial investigation of identified criminal offences, and that applies to SAPS as well as municipal police services, to make disciplinary recommendations in respect of members of SAPS and municipal police services resulting from investigations, and to enhance accountability and transparency, again recognizing that this is for SAPS as well as municipal police services. So in conclusion, while our recommendation is quite simple, the underlying cause for concern is, we feel, deeply worrying and profound. We've provided a quote here from the former United States Justice Felix Frankfurter, who touches on something that is a concern for any modern society, and he says that it's a little bit wordy, I must apologize, but he says the accretion of dangerous power does not come in a day. It does come, however, slowly, from the generative force of unchecked disregard of the restrictions that fence in even the most disinterested assertions of authority. And so effectively what he's saying is that oversight and accountability ought to not just be concerned about the big atrocities, but we should all be acutely aware and highly suspicious of small, isolated, and seemingly insignificant displays of authority, because these little isolated acts taken accumulatively over a long period of time are the disregard for authority that we ought to be very concerned about. And what we see in terms of oversight for law enforcement operations is a lacuna, is a gap, and the failure to remedy this impunity in the way that law enforcement operates will keep us will potentially put us on a path towards repression. and also increase existing levels of mistrust between members of the community, and the important role that law enforcement is supposed to play in society in terms of maintaining the law of order as well as peace between people. And those are our comments. So once again, I thank you so much for the opportunity to make these representations.
Thank you very much for your presentation. Thanks very much. Honorable members, do you have something to say? Tundifuna ukwazi. Honorable Ted Blanche.
Chairperson, thank you. I want to thank the presenter for also throwing this in the mix. And as we said earlier, we'll be dealing with all this inputs, and it will certainly assist us to get to the final product. Thank you.
Thank you very much, Honorable Ted Blanche. I'm told the presenter from the Catholic is not available. So this was our last presentation in terms of the program or the schedule that we have adopted. Nicolette, what's next?
Thank you, Honorable Chair. This effectively brings us to the close of business.
Okay. Is the DM still in? Okay. Now, thanks very much, honorable members. Thanks very much to our stakeholders who took their time to come and present their views on the IPID amendment bill. This is in the nature of democracy because the IPID as an organization is supposed to serve the citizens of South Africa. Therefore, we take pride if we see citizens having interest in the amendment of the IPID bill, so that ultimately the product that comes out is the product that has inputs from stakeholders who are representing in the main members of society. We know that it may not be possible to include everything you said. In some cases, stakeholders contradicted each other. In some cases, they supported each other. But it is the committee's purview to make sure that they come out with a balanced bill which will be received positively by members of society. And I want to thank you very much for your interest. Thanks very much, members of the committee. Thanks to the DM. Thanks to the officials from the Deputy Minister and Minister's Office. Thanks to the officials from the Secretariat. Thanks to the officials from IPID and members of the media. I've seen few members of the media. Thanks very much for your interest. Having said that, honorable members, we are going to meet again on Friday, 9 o'clock, to consider the reports, the BRRR reports for SAPS, IPID, Secretariat, and SIRA. And after that, we'll also consider the presentation from SAPS on their successes and challenges. And Babalwa and Nicolette, if you can make sure that members receive the responses from SAPS and IPIT, also Secretariat and SIRA. I think when they were presenting, members might have requested certain things to be submitted in writing. So those responses, as we said earlier in the meeting, that they'll be submitted by tomorrow. Can they be distributed to members so that by Friday, members are able to deal with them where necessary? Thanks very much, everybody. The meeting stands.
Thank you, Chair. Thank you, Chair.
Thank you, Chairperson.